truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name, organization, and designation.
My name is Kai Howie. I'm the General Counsel of G7 Renewable Energies.
Then I'm going to ask Madam Sigwe to switch on her camera, and then also to raise your right hand, Madam, and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name, organization, and designation.
My name is Oratile Sikwe, and I am from G7 Renewable Energies as the Research and Development Analyst.
Thank you. Please remember to forward your presentations to public hearings at nesa.org.za. You may proceed with your presentation. You've got 15 minutes. Thank you.
Okay, you're mute. Okay. Hi, Chair. I hope you can hear both of us. Can you please pull up the presentation? Mr. Chair, can you please confirm you can see our presentation?
Yes, I can see the presentation. Thank you.
Okay. Thank you, Mr. Chair. There's a lot to get through, and as you've indicated, time is limited. So, by way of introduction, we thank you for the opportunity to present on this incredibly critical and incredibly important and timely topic that we need to discuss in respect of the transition towards the electricity market. From our perspective, and I'm speaking as a generator, as a South African developer that is looking to participate in the market and generally looking at our business going forward, this piece of the puzzle is a critical piece in the future of the entire electricity supply industry. It is a useful piece in that it provides benefits as outlined in the paper to both the existing incumbent, but then also creating the room for transition roadmap into a liquid market. And it also provides certain guardrails that can be used to ensure that market power is not exercised to the detriment of South African electricity consumers. However, should there be issues within this process, whether it be on the structure of the vesting payments, the duration of it, whether it's for an indefinite duration, to the extent that it leads to liquidity issues in the market, which don't allow new entrants to then participate in SAWEM, and the timeline of the vesting is contingent on there being this liquidity, we believe it could create a negative feedback loop that significantly represses competition. It can lead to higher prices than otherwise would be achievable, and would ultimately lead to the detriment of the overall South African economy by having us being relatively uncompetitive. So it is within that context, Chair, that we've gone through this consultation paper quite carefully, and we've submitted voluminous submissions in respect hereof. And I'm not going to be able to get through the detail of that today, but I am going to try and work through some of the key points that we see. And ultimately, Chair, our objective in our comments is to look at the behavior that could potentially happen under the vesting contract framework, and basically judge it against the standard of, would this lead to competitive bidding in the day-ahead market that would promote competition and allow for that liquidity to be realized, or would it create room for the dominant legacy player to underbid within SAWEM and look to then recover its costs through the mechanisms that are being created here, as well as in the unbundled wholesale tariff. So it is within that context, Chair, that we've approached our commentary on this and approached our analysis. So looking at the elements that then created effectively the regulated or recoverable revenue base, made up of three components from our understanding: effectively your fixed component, your ancillary services component, and then your short-run marginal cost component. So we view this as obviously having a market distortion effect to the extent that, unlike private generators, which have to recover all of their costs, either through some sort of existing bilateral deal or through open bidding into the market, it creates room for Eskom to effectively have revenue recovery options that sit outside of a market. And so with that, we really are encouraging those to think very carefully about what forms part of that potential bucket, because ultimately that is where it allows Eskom as the dominant player to effectively be guaranteed of recovery independent of market outcomes. So in that regard, also, and also tying into that and second on the back to that of, what costs should they be considering when submitting their bids into SAWEN? So looking at that, things such as the carbon taxes, for example, the environmental attributes, insurance costs, the costs that would ordinarily by a commercial bidder have to be recovered through the day-ahead prices. We think that should not be included in sort of the fixed basket, but rather we should be saying to Eskom, you should be looking to recover those costs within your day-ahead market. And with that, looking at that, we'll get a bit more into how we believe Eskom should be bidding to the day-ahead market. We believe that these also need to be considered on a case-to-case basis by looking at the circumstances around each Eskom power station. So, for example, where you have a power station that's been in operation for 40 years or thereabouts, there should not be any depreciation that needs to be amortized on that power station that would make it uncompetitive. It is effectively as an operating asset, the capex should have been recovered by now. And we believe that attention should be paid to that in terms of how each vesting contract is ultimately structured to take that in cognizance. And that effectively what we need to have is to have an environment in the end where critically the day-ahead bidding effectively mimics what a normal commercial bidder would be doing insofar as that is possible. It is obvious that there are certain costs, and our presentation is not saying that there absolutely doesn't have the cost need for in the fixed bucket. We are completely cognizant of that, and we support that, but we believe there has to be transparency and a lot of applied thinking and thinking about what forms part of that bucket, particularly in respect of capital costs where there are recovery concerns, some of the new builds or say, for example, the Koeberg extension. But moving on from the fixed cost recovery onto ancillary services, this is one of those buckets where we believe it's inappropriate to have this as a bucket. And the reason for us saying that is, we're looking at the draft market code at the moment, and it provides mechanism to recover the costs of providing, first of all, capacity for ancillary services, but then also the actual utilization of those services by the system operator. So we believe that there are already within the market environment, there are sufficient mechanisms to fully compensate the generators who are providing that. And then it ties into our argument about promoting competition, because with the emergence of battery energy storage systems, they have ancillary service forming capacities. Depending on the configuration, it can even go so far as islanding and black start. But beyond that, on sort of instantaneous reserves, regulating reserves, and so on, they are very capable of providing those. And we believe that to the extent it's cost competitive for those generators provided vis-a-vis the Eskom fleet, from a system operator perspective, what matters is that those ancillary services are available. And that the remuneration mechanisms should be competitive and should be cost competitive to allow that to happen, and the structures in the market code itself have to be designed to make that sufficiently commercially attractive for generators to provide that. So, we believe that in respect of the provision of ancillary services, there are already existing mechanisms that have been proposed, outside of vesting contract framework to deal with that, and we would encourage NERSA to think very carefully about how that gets dealt with to ensure that we're an environment that promotes competition. Now, critically, moving on to the short-run marginal cost. effectively, there's a number of elements that made up this, and we support those elements. We think that perhaps some of those from the fixed cost basis in the consultation paper perhaps need to move over, like, for example, the return perspective. Eskom should be incentivized to get their returns through their bids in the short run market. And effectively, if you're looking at this provision from a vesting contracts framework, this ultimately is a very useful tool within the vesting contracts to regulate the behavior of the incumbent generator in how it bids. And it's both got downside protections. In other words, it ensures that Eskom should ensure that Eskom doesn't artificially lower their bids to reduce new entrants entering into the market, and so prolonging their privileged position under this vesting dispensation. But it should also contain guardrails in ensuring that the bids aren't artificially high as well, which, even though it will be netted off by the mechanisms involved in investing, could deal with certain, short-term immediate cash flow constraints or other behavior that would be detrimental to both the distribution arms and other distributors, but then also the consumers at large, South Africa at large, really by creating liquidity issues on the other side. So effectively, what we are saying here is that it's one thing to have this regulated revenue pool that should be recovered from the day ahead basis, but we also, within the actual vesting contracts, and I think this needs to be elaborated a little bit more within the paper, exact mechanisms put in place, and especially on things like the flexibility margin that is envisaged, that really regulates how exactly the dominant legacy generator will be acting within this market, particularly to allow for new entrants and liquidity to come in. And I think this is an area where this vesting contracts framework can be very powerful and can be well utilized. But at the same time, if it is not well defined, and if it does allow for behaviors that otherwise would not be expected from a commercially minded generator into SAWEM, that will have significant impacts on liquidity and the general competitiveness of the wholesale market going forward. So we would encourage NERSA to think very carefully on those topics. Moving on now to sort of the final point we want to make in this presentation, which is really about the vesting volumes, but then also sort of the duration of the vesting contracts. I see Kobia is getting ready to present. Look forward to your presentation. But on the vesting contracts and the vesting volumes, this is a critical piece that needs to be considered for effectively two reasons. The first reason, of course, is that, as it's currently envisaged, the vesting volumes will change depending on the liquidity in the market. Now, there's a risk here that we get into I don't want to call it a doom loop, but effectively a non-virtuous cycle where because of the behavior of Eskom as the initial price setter, initial market participant, the prices being achieved in the day-ahead market are artificially low, which means that participants cannot build an investment case to enter into SAWEM, which means that they don't, which then means that the additional liquidity that NAVSA would be looking for to relax the vesting regime would then never be in place. And this is something which we view as being highly undesirable, because it effectively locks South Africa into a anti-competitive environment whereupon depending on how the wholesale pricing framework looks like, where if coupled with significant capacity fees for consumers, could result in effectively Eskom and the CPA through the regulated program being the only sort of commercially viable processes in town. And we think that would be self-defeating of the reform agenda that is trying to be achieved in creating a competitive liquid market. So ultimately on that, where we are coming from is that ideally we should be thinking about the timeline of this vesting regime as being time-bound. We've put a proposal in there which we believe can work of starting at 80% of vesting volumes and progressively working down over a 5-year period. No doubt other people in this hearing will have different ideas about how it can work, but we think that it needs to be independent of liquidity, but then together with that, in the actual wholesale market regime, in the nurse exercising its regulatory oversight, there has to be sufficient market monitoring mechanisms put in place to ensure that behavior is commercially minded, that it is robust, and that players are not abusing their dominant market position to the extent that they have one. So I'm going to end our presentation on that point, but with the conclusion that the vesting regime is a critical and important part of the process. It's got many useful aspects to it in terms of how we approach the transition. But we have to be very, very careful as a country, as South Africa Inc., and as a regulator, that we get this right to avoid some of the negative consequences that can be foreseen under certain circumstances. And I appreciate that the document itself is a complex document, and it does sketch out many different scenarios that to be considered. But I think for the key risks that we've highlighted above, we would appreciate it if a regulator gave significant consideration to ensuring that when the vesting regime is ultimately adopted, it allows for market competitive behavior that then promotes liquidity going into the wholesale market and eventually and hopefully lower prices for South African electricity consumers. Thank you.
The members, on show of hands, if they've got any questions for the presenters. Over to you, members. Let us start with Madam Maseti.
Thank you, Chairperson, and thanks to G7 for the presentation and the issues that they have highlighted. I just want to start off with the last slide on the vesting volumes. I get the concern that you have raised. However, I just want to zoom straight to the proposal that you are making, that at the beginning, you are proposing 80%. My question is, don't you think that is very high, particularly from the perspective of a market development? Is it not something that you believe is high? And then also linked to that, how did you come up with the 80% that you are proposing? I think that for me is important as a regulatory issue, because that 8%, or at least if that 80% is going to be a minimum transitional hedge that is necessary to protect against an immature market. So if you can just clarify that, and also just deal with the critical nuanced issues around that 80%. And also issues such as the consumer protection, for example, just in terms of the spot price shocks, if you can just deal with those kind of issues. Then I would like to move on to the question on the duration, because you raised the issue, the duration of the vesting contracts. I guess this is it has the pros and cons, the issue of the risk. Whether NERSA, because I think we want to hear from stakeholders and appreciate the risk, whether NERSA must actually consider sort of a single calendar time, say we fix 5 years or 6 years or whatever time period that we fix. I know that the framework itself is open-ended when it comes to this aspect. because we wanted to hear from stakeholders what they're going to say. Although we talked about market assessment and we did not indicate the triggers for that market assessment on this aspect. So it's two things. Whether it's going to be a particular, date, time when this comes to an end, appreciating though the risk not only for Eskom. So if you can touch on those risks in terms of maybe cancelling these the what you call the transition, too short, and then it will have implications. But again, if we extending the period, the risk associated with that. So it's actually on both when one fixes the period. But again, as the framework proposes, the market assessment, yes, it does fall short in the sense that it did not provide a criteria or certain indicators, market indicators that will trigger the market assessment. I would like to hear your views on that in terms of your concern that this should not be an indefinite thing. And I agree with that. And I think everybody does. But at least between these two options, what is it that we can actually do here? If we have to come up with the triggers so that we don't just throw in the market assessment aspect without at least dealing with the triggers for that market assessment. Chairperson, I would like to leave it at that. Those for me are the two critical questions that I just wanted to pose to G7. Thank you, Chair.
Thanks, Madam Masedi. I'm now going to call upon Mr. Sibanda.
Thank you, Chair, and thank you to Mr. Howie and Ms. Sikwe. Chair, probably Ms. Masedi has covered me regarding the 80% of the vesting volumes to start off with. My question was also why 80% basically? Why not 60? Why not 75 or anything of the sort? How did you come up with that? And also around the triggers for the vesting period. But perhaps the one question that I can still ask, I think you've probably characterized the issue that we're trying to deal with here, which is during the transition, ensuring that the incumbent generator does not abuse its market power, but also is not disadvantaged as we transition to a competitive market. Now, you highlighted the possibility of the incumbent underbidding through SAWEM and then recovering those costs through the generation pricing and investing contracts arm of the system. What practical mechanisms can we work with or implement other than active monitoring? What practical mechanisms can we incorporate into the framework to avoid the possibility of underbidding, if at all possible? Thank you, Chair.
Thank you, Mr. Sibanda. I now call upon Mr. Mkhize.
Thanks, Chairperson. Thanks, Mr. Howie and Madam Sikwe. I'm likely covered by my colleagues with the understanding that if we're looking at the vesting period being a transitional measure, just to understand in terms of the triggers, and not maybe get fixated on the time frame per se, but look at the how things progress in terms of the triggers and the thresholds as you move along. Talking also to the issue of that 80%. But the additional question I have over my colleagues is one that deals with the fixed cost recovery. You said there are no specifics in this regard. What would you propose be done to, or what should form the fixed cost recovery? And then you talk of also of least cost methods. Do you have any specific suggestions with regard to that? Thank you.
Thank you, Mr. Mkhize. So at this stage, then, I'm going to ask our presenters, Mr. Howie and Madam Sikwe, to respond to the questions posed by the members.
Yeah, thank you, Mr. Chair. Thank you for detailed questions. So I'll touch briefly on the vesting volumes for a moment before moving to the other questions. So on the vesting volumes, I think as an industry we have to bear in mind that there's both a protection for Eskom generation, but there's also protection for the distribution in industry. And I think from when we were considering the risks, that we thought that it might be important for there to be protection for the distributors, especially in an environment where initially the deregulation of the retail pricing might not yet have been affected. And, depending on where the wholesale pricing volumes land, there's a lot of volumetric risk that could be placed onto the distributors. And we believe that does have to be carefully considered. So that's perhaps why our approach was maybe a bit on the conservative side. But what I will readily admit is that, we are energy project developers. We do not have the sophisticated economic expertise of some of the other experts that might be presenting in this call. And we made this judgment based on perhaps the less sophisticated methods and what might be applied by professional economists. But we do think that generally we also have to think about the protections the vesting regime will offer onto the distributors and how important it is and what a critical role player they are in a sustainable transition into the market economy, or liberated market. So then sort of moving onto spot price shocks. I mean, that again, it touches a little bit again on the distributors. It can become a cash flow issue in SAWEM, where there are higher wholesale prices that what may or may not be on the regulated distribution side. And that can cause difficulties that we believe there needs to be cognizance of and thought given to what that could mean. Now, looking at the duration, and I appreciate the comments raised in regards to this. So from our perspective, a set calendar time is preferable because it is the most certain. We are obviously, our primary concern is this negative market forming loop, which would effectively lock in this preferential arrangement. But if it is not based on basically on an inflection of time. So in terms of looking at sort of the market conditions as well, it's a critical component that we have to get the day ahead and SAWEM right and create an environment that promotes investment. Now, investments that come in would generally not be looking at price setting, from reduction of risk, because the question will always be asked, for entrants looking into SAWEM is saying, about how much could the prices reduce by before this asset is no longer dispatched. So we believe that it's effectively the key criterion here is where's the day ahead price set? How is it set? And what is the composition of that stack, if I can call it that? and then that would then lead to additional liquidity that would then later flow in. But it is quite critical that as a market we get confidence in the stability of the day-ahead market as well as its movements, so that we can then take views and be able to justify investment cases. And that is something that the vesting contracts can help promote through various mechanisms. Now, I was asked about the adjustment mechanisms, so particularly where there's been underbidding. And while certainly legally, in terms of forming it, in terms of contractually, really, sort of in terms of drafting, really, it will be difficult. But there absolutely has to be an adjustment mechanism, so as not to award revenue adjustments to the extent that a power station, for whatever reason, is underbidding. And to point to my presentation, I didn't touch on, but it is there. We have to think very carefully about how these generators are bid into the market, in terms of whether they indicate whether they're flexible, inflexible, what their step changes look like, to ensure that we actually have a constructive and accurate bidding that goes into the market. Otherwise, it could exacerbate some of the levels of curtailment that we are seeing in the market. But that has been elaborated on in the presentation as well as in our written submissions. And tied into that is the fixed cost recovery question as well. Now, for example, what we've used as an example is the issue around depreciation and recovering that capital expenditure. That is important. There's a few methods that perhaps could be given consideration. You could be looking at the actual repayment of the loans for each of those individual power stations. That could be a method that could be looked at. Things such as insurance costs, there needs to be a debate about whether that gets pushed out into the variable pricing. But that, yet again, we dealt with in a lot more detail in our written submissions. And I'll leave the questions there, Chair, sufficiently.
Thank you, Mr. Harry. So at this stage, then, we are going to go to our next presenter, Mr. Claassen. So, Mr. Claassen, may I ask you to switch on your video?
It's switched on, Chair.
And then I'm going to ask you to raise your hand and affirm the following. Do you solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth?
Solemnly declare.
For the record, please state your name, organization, and designation.
I'm Cornel Claassen. I'm a manager at the Energy Council of South Africa.
Thank you, sir. Please remember to forward your presentation to publichearings@nesa.org.za. You may proceed with your presentation. You have 15 minutes.
Thank you, Chair, and good morning to everyone. Thanks once again for the opportunity to present this, our submission. I'll start by just prefacing that this is enormously complex work, and NERSA has really applied themselves to this, and I do commend them. Given the complexity, it's impossible to cover everything that we've done, but I'd like to just go through key points of our submission or key issues that we've discovered. It is a good framework, and we do support the mechanism itself, but it would need some revision before it is actually workable. So, considering the purpose of vesting contracts, they must always look at stabilizing generator revenue during the transition, but also, very importantly, managing the risk of market power. And these two sometimes can become conflicting, and it's important that we always look at a design that caters for both. So we've gathered members and done a workshop and a series of inputs based on 3 principles we've established to see whether the vesting framework would lead to efficiency and prudency, and whether it adequately provides for transparency measures. And lastly, very importantly, whether it caters for the market compatible transition. So whether it is designed to have a credible pathway towards full competition and exposure eventually. Our key issue is with transparency is that the vesting framework doesn't really stipulate what should be transparent or published and what not. So the framework itself is a principle-based document, so it doesn't have to have all the transparency, but it should indicate what of vesting contracts and the parameters will be publicly available or not, which is a key aspect. Additionally, for our submission, we did consider that the design should reflect how the market is meant to operate. And this is quite important, that we try and mimic real market operation as closely as possible, because it leads to less disruptions when we lift mechanisms or transition to competitive capacity, for example, and matches how the market should operate, which is on a least cost and economic merit basis. So vesting contracts, of course, should be recognized as a transitional instrument, and it should always maintain dispatch integrity, which is the real outcome or benefit of SAWAM. So our key principle then on our submission was that the capacity payment upstream must equal the capacity charge downstream. So the key reason for this is the charge should always match to ensure we don't just shift volume risk elsewhere or under recover, and that we maintain the price signals to reflect the true cost of capacity. Of course, the full fixed cost of a generator cannot or should not be passed on to consumers one-to-one. And if it's just passed on, then eventually it will impact and disrupt the EDI or the distribution sector. So it's important that the volume risk is balanced between up and downstream, but also that it can easily make the provision for transitioning to the capacity remuneration mechanism once it's launched. So this design ensures that once competitive capacity is launched as part of SAWAM, that we don't have to revise the entire framework because it's already reflective of a competitive capacity signal. So this way, again, we design vesting contracts to reflect real market operation as closely as possible, making sure we can independently adjust and transition as necessary. And we know from the roadmap that once SAWAM is launched to external participants, the next big step will be the capacity remuneration mechanism. So it's likely that vesting will have to be adjusted or adapted to that mechanism. The second thing then is the offer price and the strike price. Now, we do support the separation of these two, but we found that there's more to it, and the function of separating offer and strike price is actually also the real mechanism for managing market dominance. So the first big reason for this is if the capacity remuneration is more competitive based, there will be some revenue gap that needs to be closed. And if we adjust the strike price accordingly, it mimics real market behavior that allows generators to make profit from infra-marginal rent, so just the difference of the market, their offer price and the market clearing price. This way then also preserves dispatch signals, because short-run marginal cost offers are common in markets, and the system then dispatches the cheapest available generation. If we don't do that, then we start skewing the price and we start overbidding because your offers is more than what the least cost bid into the market would have been. Very importantly then, under point 3, this will allow us to separate the two primary functions of vesting contracts. So the strike price itself is hedged against revenue instability, and the offer price protects against market dominance. And these two mechanisms must be administratively separated, because ultimately we know that anti-competitive potential will remain for much longer than revenue stabilization will be required for. So that way you can expose generators to market conditions, but maintain the anti-competitive mechanism, and that can be managed in its own way. And then lastly, of course, this way we do keep the real market operation, or we mimic how a market should operate, because we know stations have, the vested stations will recover capacity and ancillary service costs. So in essence, they already have that recovery mechanism, which allows them to bid at short run marginal cost. And in normal markets, generators will then be allowed to make up for some profit in the difference between what they offer and what the clearing price is in the market. So it mimics how a mature market really would operate. Then a key issue we did find in how the current vesting framework calculates or determines the strike price, it correctly identifies the benchmark revenue requirement. Now, if we want to use vesting for revenue stabilization, we obviously must have a reference point, which for now will be the MYPD methodology. But what this framework then does is it sets the strike price as the full revenue requirement. So instead of considering that capacity and ancillary is already paid out, it adds it back into the full hedge. And what you see then is once it hedges back into the monthly production of, this was the R0 example, it actually adds the capacity and the ancillary value again on top of what is considered an additional benchmark value. So it must be addressed regardless of how strike price is calculated. Our proposal is that the strike price must be determined as the residual revenue hedge, so only what's outstanding. So it will allow the generators to recover and make some inframarginal rents, but not fully recover again against its revenue. The current example actually just double counts. So that is a key issue, and it's difficult to explain simply because the example has a 70% market exposure, and then it becomes quite difficult because at 70%, that remainder of 30% would allow a generator to either make loss or profit from the market. So the maths become a bit muddied. But if you actually apply the example at 100% vesting, you can see then in both cases whether it's under or over, it becomes immaterial because it's 100% protected. Both examples then, the R0 makes close to 720 million rand above its revenue requirement, which wouldn't be considered prudent in any case. Then a key element to our submission is that we must consider adding station classes to the NERSA framework, simply because there will be different approaches and requirements to how we develop these contracts for specific types of stations. So we propose a new build class, a mid-tier one, which is your Majubas and Kendalls, and the ones that kind of has not, it's past its peak debt service, but it still has quite a while to run. And then the N-tier ones that are close to retirement and less dispatched, as we know. And of course, peakers who are your OCGTs and pump storage, who have a completely different cost stack or profile than your thermal or your coal stations. This would really allow us to not go into too much detail in a principles-based framework, but allow vesting contracts to have specific recovery mechanisms and exposure paths. For example, we know the new builds are quite efficient and have low short-run marginal costs, so they will a bit lower into the market and can be exposed sooner because they almost have guaranteed dispatch at their rates. It also is very necessary because the different classes of stations and their age have different flexibility requirements in the offer price margin. So we must take into mind when we develop the flexibility of a station that the older ones aren't that flexible. And if we want them to be flexible, it might come at a higher premium than the newer stations, for example. It would also assist then with vesting reduction pace. Different stations would need different exits and sunsets. Specifically also looking at a cost stack of a decommissioning station. As it's being retired, it will start looking very different in terms of its fixed cost recovery. And also specifically at the end tier, there might be additional requirements to make sure we recover stranded asset costs. Unfortunately, in this proposal, we have the stations must compete to be dispatched. So in a structural oversupply situation like we're in now, it might become quite complicated if we don't create these classes, which would tremendously assist. So to close, we know that SAWM is being implemented in phases. The top, this diagram comes from the EEE SAWM workshops, and at the moment, Eskom is already operating in the day-ahead market as it's meant to be ran, essentially testing the market platform. They do bid in their numbers and they get dispatched based on merit order, so there's already a market running. And they're already being hedged back to their required revenue. So in a way, we already have a mechanism that's acting like a vesting contract. And it's important for us to know because in the later phase 1C, we will have this period where we have vesting contracts, but we haven't opened the market to external participants. And the reason why this is so critical is it allows and creates a testing environment, which will be critical for us to validate and make sure the design works as intended. So it's important that we not just consider vesting contracts as a whole, but that we will have a chance to test this and we absolutely must make sure it works before launching. But to get there, we need to move and make sure we develop the framework and the contracts on time. So I'll close there. Thank you, Chair.
Thank you, Mr. Klassen. I am now going to give the opportunity to members if they've got any questions. Thank you, members. I will start with Madam Maseti.
Thank you, Chairperson, for the opportunity, and thanks for the presentation. I just want to ask questions around the strike price because it is very important for all of us to get it right. Because if it goes wrong, maybe it's high or low, there are consequences. So it is something that we really need to get it right. So to get it right, also it's important that we are all aligned in terms of its economic rationale and who benefits if it is not done correctly, if it is done in a wrong manner. That's the second aspect. And then the third aspect that I would like you to also, as you deal with the clarity, to just try and, align it to the system marginal pricing as well as your generation capacity charges and legacy charges. I think for me it is quite important. If you can just touch on the economic benchmark on that price, I will appreciate that, because it will assist in terms of ascertaining discretionary pricing. But in the framework that we have published, there is a reference to cost reflective pricing. And there is also reference to market pricing based on benchmark. So these are two different things. And there are specific pros and cons as well as a risk associated with them. And I recall last week some stakeholders suggested, I believe it was Meridian, suggested a proxy, in as much as there's a mention of cost reflectivity as well as the market price based on benchmark. The issue of benchmark again is one that then raises a question, at least from my side, also within the context of competition economics, as to what will be that appropriate competitive benchmark that will be used to determine the strike price. Taking into consideration that our market has not even started, SAWEM has not started. It's an immature market that has not even started. So if we were to even talk about benchmarking, what are we benchmarking against? So it's very important from an economic standpoint and from a competition standpoint that we are aware when we want to use a benchmarking as to what is an appropriate competitive benchmark. So that's the first thing. And the second thing around benchmarking in an immature market is a problem of circularity. The circularity problem is tough. I know that we've encountered things like that also in other energy markets that we regulate. Because if you come from a monopoly market structure or a dominant market structure, especially the monopoly, so you've got nothing else because your market is immature. So what are you going to use as a benchmarking without getting into a danger of using the sort of the price that was used by a monopoly, or trying to use some discretion or estimate that price using information that you know, instead of allowing the market through competition to discover the genuine competitive price. For me, that is a critical standpoint in terms of the work that we are doing today. It's a discovery, it's a process, and that process will only happen at SAWEM. And that's how that competitive price can be discovered, rather than us, even NERSA itself. It can't do that estimation and coming up with that price. It is the market that must do that. Now, so both those two elements for me have those challenges, and I really would like to hear you on this, because it is very important for the regulator to get this right. Now, to try and move away from these two, there was a proposal last week that a proxy be used. And then again, that proxy, there were certain, proposals. What cost are you going to include in the proxy? And also what role the regulator is going to play, perhaps no role at all, but also just issues of transparency and so forth. Can you please just address us on that aspect. I believe for me, it is quite important. Then the second issue that I would like to just clarify with you is how could we make sure that vesting does not create asymmetry advantages for Eskom? Can you assist us on that? We have dealt with these as the aspects relating to this under section 6.16 and 6.17. Which provides for generation vesting contracts with Eskom generator and distributor vesting arrangements. So it is in the framework currently in those two sections. My question is, how do we make sure that vesting does not create asymmetry advantages for Eskom? There is, I get your other point about the market abuse and all of that. Perhaps there's another element of market abuse that we have not, or I haven't heard stakeholders touching on it. I take the one that was mentioned by the presenter earlier on predatory pricing, like to bid at a very low price, substantially low, such that it will not cover the cost. And therefore also compromising the profit. But you're doing that knowing that you've got other associated markets where you have the opportunity to recover what you have lost in this energy or the electrons market, where the bidding is and competition is quite fierce, and therefore you are recovering elsewhere. So the presenter touched on that. So that's one aspect of the market abuse. But the one that I have not heard is it relates to the relationship between the CPA and Eskom. As we know that CPA will be a counterparty to Eskom, and yet it has to buy and then trade. So that the exclusionary conduct and foreclosure aspect, which is an abuse of dominance in terms of Section 8 of the Competition Act. I know that this is not our role, but through the MOU, we work together. So on those aspects and exploit the necessary synergies between the two regulators. So I would like you to also look into that aspect of exclusionary conduct or possible foreclosure through an exercise of market power or abuse of dominance. How would you advise that we deal with that potential abuse of dominance in the same way that the issue of the predatory pricing was mentioned earlier on? Thank you very much, Chairperson.
Thank you, Madam Maseki. I now call upon Mr. Mkhize.
Thank you, Chairperson, and thanks to Energy Council for the presentation. From my side, just got two issues. Firstly, I appreciate the presentation around the issue of the strike price and double counting. I take it that double counting is an embedded principle. I mean, the elimination, in other words, of double counting or double dipping should be an embedded principle in terms of the framework. Just maybe to a comment in terms of saying, because we are talking about something we are going through, not what we are in currently, as to what other measures do you think need to be put in place to make sure that any double dipping or double counting is speedily addressed to avoid any challenges in this regard? I just like to get to understand that. And then when it comes to the dispatching of power at power station level, I would like to ask from your side if you foresee any situation where maybe in the beginning will be neutral and only look at what comes from Eskom, in the sense that there could be maybe other reasons to keep one station still running for whatever reason, and then but it is deemed. I'm saying that it becomes a deemed system instead of an actual system that, yes, indeed is coming from this particular power station, but that it's considered to be flowing from that power station. That's all from my side. Thank you.
Thank you, Mr. Mkize. I'm going to now call upon Mr. Sibanda.
Thank you, Chair, and thank you to Mr. Claassen. Chair, from my side, so I think you raised the important issue regarding transparency and the importance of information disclosure. And yes, information is quite key for the functioning of any economic system. I think what would help perhaps is if you've got suggestions on the type of information that you think might assist in terms of disclosure. And then secondly, your proposal regarding having station classes for vesting contract design, don't you think that might complicate the framework or introduce complexities into the framework? For instance, there could be a debate on what criteria to use, for instance, to classify stations. And I know that you had some criteria there, but there can be, those can be debated. Do you think it's something that you would want to see, and what about the complexities around that? Thank you.
Thank you, Mr. Sibanda. Let me now hand over to Mr. Claassen to respond to the issues raised by members.
Thank you, Chair. Thanks for the comprehensive questions. I wouldn't presume that I'll have another 15 minutes. So I've taken very detailed notes, and whatever I don't answer, I will make sure to submit in writing. So to Madam Massetti's first start on strike price and the economic benchmark and circular counting, the issue is at the moment we do still have to recognize that we are under a revenue determination period. So while vesting runs will have to hedge towards some reference, which might be MYPD 6, that essentially creates the full cost stack required. But our proposal essentially separates a lot of the cost drivers. So we must be sure that the offer price is prudently based on short run marginal cost, and not baking in other figures. And if we then look at the other payments deemed, if we do reference a capacity payment that is referenced to availability of a peaker or other competitive mechanisms, we know there will be a residual revenue requirement, and that already in itself creates quite the incentive to be efficient and flexible, because flexibility means more guaranteed dispatch, and you will need to be dispatched in any energy market to recover your full revenue stack. So that, combined with what's called the benchmark energy quantity, or essentially a benchmarked production plan for a period, if it's a month or a year, must be closely looked at together and continuously assessed. I think it's quite important. Our submission does provide more detail on that, but NERSA must also look at capacitation in the regard of not just oversight, but modeling and also running shadow calculations to Meridian's reference. There will have to be consistent references and inputs and models to compare with, and we must always continue to assess the market's efficiency versus its actuals and what we would expect from an efficient market, and that's a key oversight issue that will need to be addressed. It's important also then to just cover Mr. Sibanda's point together with Madam Massetti's on developing the benchmark, not just looking at MYPD, but looking forward what future determinations needs to exist. And in terms of that, that's where the station classes also really come in, because a benchmark for a station that's planned to be retired soon is going to look significantly different to that of a new build, like, for example, Kusile. And its entire stack and how we treat vesting must be different. And the stations closer to retirement should provide triggers, for example, as soon as it is retired, to reassess the vesting contract, which Kusile wouldn't need because they'll outlive vesting by far. It's also important that we keep in mind that the market will mature, and vesting contracts will less and less point to circular references as we introduce more competitive procurement mechanisms. So the capacity remuneration mechanism is very important. It's important that we don't create vesting contracts that has an indefinite period to capacity payments for Eskom. It must have a clause that transitions to the competitive capacity procurement, and it will be very important that might be phased in as well. They might need a special vesting period for that to make sure they gradually introduced. But the way we propose already provides for a very close capacity payment to that signal. So the adjustment should, in this case, be minimal, and that's why it's so important to design vesting contracts that, as closely as reasonably possible, mimics how a real market would operate. Then on the asymmetry advantages for Eskom, I mean, that's quite a difficult challenge. I think it lies in equaling the capacity payment upstream and the charge downstream, but also making sure we are aware that fixed cost recovery is a risk mitigation tool for a generator, but it's not free. I mean, that risk then gets passed downstream. So the same business at this stage, Eskom generation, would have an asymmetry in risk management if the capacity payment isn't structured well. So, I mean, it's the best way to handle it with what we propose, but we should also be aware that the vesting contracts downstream should be carefully designed, keeping in mind that we introduce fixed cost that isn't reflected in the retail tariffs yet. And luckily, I mean, it's quite intentional, so that risk doesn't exist if distribution has a vesting contract. But exposure mechanisms should also consider the fact that downstream recovery for distributor must be aligned to wholesale tariffs and vesting before the risk is adequately managed. I think perhaps it might be best to hand back to you, Chair, and everything else we will respond in detailed writing.
Thank you, Mr. Clapton. And indeed, we're looking forward then to further written submissions from you in response to the questions raised by members. So at this stage, I'm going to call upon the next presenter, Mr. Rovieski, from Meridian Economics. Mr. Steyn, may I ask you to switch on your camera?
Morning, Chair.
And then please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name, organization, and designation.
My name is Framewo Steyn. I'm the Managing Director at Meridian Economics.
Thank you, sir. Please remember to forward your presentation to public hearings at nesa.org.za. You may proceed with your presentation. You have 15 minutes. Thank you.
Thank you, Chair. My apologies for disrupting the screen sharing of our colleagues at G7. So this presentation, of course, follows on from our presentation to you last week, and thank you very much for the opportunity to present to you. As we said last week, this work was commissioned by the Energy Traders Association, but was developed independently by us. Our mandate was to focus on serving the broad public interest. SAITA members have indicated that they broadly endorse our submissions, but of course they will make any further submissions as and when they need to do so. And very importantly, given the very limited time for this presentation, we focused only on very key high-level strategic points. There are many important points that we can't make today, but are included in our written submissions that we have and presentations that we have submitted to NERSA, and that is also available on our website under publications, including this presentation. So perhaps let's start just to recap some key points and considerations for how we think about what we are busy with here, with reforming the power system and with putting in place the vesting contract framework, which is the topic for today. Essentially, the key rationale, of course, for all these reforms is that the vertically integrated monopoly model has run out of road. It has delivered prolonged supply constraints in South Africa and dramatically rising prices, which is now causing a big crisis in our economy. And the system can't finance the investments that we need to replace the aging coal fleet. So that's the background for our reforms in a very short, small nutshell. And that's why our government and our parliament has legislated to introduce the reforms we're talking about today. The critical point is that the purpose of the point of competition is that it shifts the risks off consumers. SALWEM will move the investment risk from consumers and taxpayers to energy companies and their investors. And it will discipline cost through competitive rivalry rather than regulatory negotiation. So that's the fundamental change we are trying to achieve here. Critically, prices must therefore signal scarcity level, not average sunk costs. In a competitive market, price is information. Energy is priced at the short-run marginal cost and capacity at the marginal cost of new entry. So prices then rise when supply is scarce and fall when it is abundant. And this will draw in investment exactly where and when it's needed. And this is also what drives efficient dispatch, sends the correct investment signals, and also signals for sound consumption across the whole economy. So, and this is the critical point, this next point. The public interest is therefore not a particular price or a producer's revenue. It is in efficient price signals that drive reliable electricity supply at the lowest sustainable cost over time. Regulating for market transition therefore asks a different question. The question is not how is the approved revenue recovered, but as I said last week, what would the market price be and how does every component converge on it? So we need a different paradigm for this different task of transitioning to a competitive market. However, as we all know, Eskom remains dominant. It's not horizontally unbundled for competition. And this is a bigger issue than we generally make of it. Generally, when one wants to introduce competition into a market, you have to restructure the sector so that you actually have competitors and competition. We have not done that yet, and that presents an enormous regulatory challenge. Competition alone cannot constrain market power in the early years for this reason. Vesting contracts and regulated Eskom generated bids into the day-ahead market will be required for as long as Eskom is dominant. Let's talk about another elephant in the room, and that is Eskom Generation's legacy financing obligations. This legacy or strand of this debt, some of it might be stranded, some not, needs to be addressed head-on and explicitly. And this analysis should be based on the actual debt instruments on the Eskom Holdings balance sheet that relate to generation. To the extent that this debt is stranded in the context of efficient market pricing, a reasoned allocation of costs between the shareholder, financiers, and consumers should be worked out. And I should maybe just repeat what I said last year. Eskom has already received in the order of R500 billion of financial support from the government. So that should definitely have reduced any stranded debt problem that we might have with respect to the generation plant. If someone is to amount to anything, efficient market prices should not be distorted by opaque regulatory methodologies, which are trying to recover stranded financing costs. We should aim to have efficient pricing and separately deal with our stranded cost issues or stranded debt issues. A second important or further important consideration actually is that the current MYPD methodology that is essentially carried over into the proposals we're currently discussing that NERSA has published is effectively and has always been unimplementable. So this might sound like a bit of a controversial statement, but the facts clearly support this conclusion, right? NERSA faces powerful opposing pressures. It has to recover Eskom's costs when it sets tariffs, and including the financing costs associated with the assets that Eskom has constructed. That's what we refer to as the regulatory asset base. It actually refers not to the assets, but to the capital structure that funds the assets, on the one hand. On the other hand, prices need to remain affordable. And as we've seen over the last 15 years or so, it's been incredibly hard for NERSA to deal with this, and actually there's been severe problems on both sides of this equation. Actually, if we apply the MYPD method correctly, in other words, we take the MAV RAB and times it by the WACC, it would result in unaffordable electricity prices, right? Completely unaffordable. As a result, Eskom and NERSA have never applied the full RAB times the WACC formula correctly. And this is clearly disclosed and has been in NERSA's decisions over the years. For example, the most recent MYPD 6 decision uses a 4% real pre-tax WACC when both NERSA and Eskom agree that the actual correct WACC is somewhere between 10.7 and 10.8. So this really has put NERSA in an impossible position over the many years now. The MYPD methodology is in effect unimplementable. And the question is, why then should we carry this over into this new vesting contract framework that we have to set up now? So, as I said, the vesting contract proposals retains the same basic mechanism. It works with essentially an allowable revenue calculation, which still relies on MAV RAB times WACC. And as our colleagues from the Energy Council pointed out, there's a double counting of the capacity recovery because it's also an energy charge. But the key point here is MAV RAB valuation has no relevance in the context of the SALWEM, right? As we said last week. This approach generates sufficient revenue, if you can apply it, to replace the coal stations with equivalent new coal stations, an assumption which now clearly is no longer appropriate. Future capacity additions will come from competitive market participants, bringing their own financing and technology choices, I should add, and bearing their own risk, not necessarily from an incumbent regulated monopoly that continues to socialize investment risk. I mean, that's the whole point of moving to a SALWEM and setting up these market reforms that we're talking about today.
The MEV RAD does not reflect the efficient marginal cost of capacity from legacy stations and is incompatible with how capacity will be priced in the market. It does not distinguish between the economic cost of providing capacity services from legacy stations from the inefficient or stranded cost of that capacity. So let's look briefly first at the NERSA proposal, and then we'll go to the market proxy proposal that we're proposing. So the first part here is just how the payments flow through the SAWEM. Obviously, Eskom generation on the left generates the power and bids it in at the regulated short-run marginal cost. However, power stations get paid at the system marginal price, which is the short-run marginal cost of the most expensive station that is dispatched in that hour, right? So most stations will make infra-marginal rent. They will generate, the system marginal price will pay them more than their short-run marginal cost of producing energy. So they'll make a margin, infra-marginal rent. Of course, Eskom distribution and other market participating players will be buying that same power in the SAWEM also at the SMP. However, Eskom distribution, while it's buying this power at the SMP, will be paid by customers at essentially the regulated wholesale energy charge, right? And that is that's based on the MYPD method we've just discussed after all the other costs have been deducted. So the energy charge will be a calculated residual, and as we explained last week, results in a recursively declining energy charge and growing legacy charge in subsequent periods. So a key point here is that Eskom distribution will be paying more for the energy in the SAWEM than what they'll be getting from customers in the energy charge. So now we just look at the effect of the hedges as they are proposed. The upstream hedge, so Eskom, each power station will earn the SMP in the market. The effect of the hedge with the CPA for each station will essentially bring them back to the regulated revenue requirement, the MYPD revenue requirement. That's what happens upstream. So the CPA is likely to have to pay out money to the generators. Downstream, while the distributors will be short, they will be hedged in the hedge. They'll be hedged back to the hedge will compensate for the fact that they're paying the SMP and only earning the regulated wholesale energy charge. So the hedge will pay the money to reduce the effective SMP payment to be the same as what they get from customers. But of course, that creates, now the CPA is paying upstream and downstream paying out cash, right? So of course, it will then have to recover that shortfall in the legacy charges, but only in subsequent periods. So this creates a very real and very, very significant problem. There are some further concerns here around the volumes and what the strike prices don't match, and there's some also very important volume asymmetry between what the hedge upstream and the hedge downstream. Right, and then lastly, the way it works with capacity is the CPA and customers will pay the generation capacity charge, and that's what will be passed on to the CPA. However, the capacity payments from the CPA to every power station will also be based essentially on the regulatory asset base, right? So that will be the fixed generation capacity cost, which will be, again, more than the generation capacity charge will generate, and that will then cause a legacy charge back to consumers in subsequent periods. Again, they'll create, not only is this economically not necessarily the rational way of doing it, but it creates a significant timing problem. Right. Then lastly, how do we deal with the stranded debt? Well, the generators end up with all the margin that's being made, right?
and they then, in effect, will pay that over to Eskom Holdings. This will be opaque. It will not be visible to us and even to the regulator. So here's the full picture, which of course we don't have time to discuss today, but is included in our written submission with much more details about how the current proposal works. Let's look now at the alternative. Let's try and work through a very, very high-level overview of how the market proxy proposal can work. Of course, each generator, power station, sells its power into the SAWEM as before, and they get paid the clearing price for every hour. Eskom distribution or any other participating distributor in the market pays the same price for that energy. Then importantly, we've proposed that the wholesale tariff and the energy charge and the wholesale tariff must be based on a forecast, because obviously you have to set the tariff in advance. So it's based on a forecast, a modeled forecast for what the S&P prices will be. So that what we're trying to do here is we're trying to match what customers pay to what the distributor will pay in the SAWEM. So we're not building in a systematic difference. We're trying to get them as close as possible up front. So therefore, then the hedge with the CPA is only there to correct forecast errors on the energy charge, right? So it won't be anywhere nearly as big as it was, and it'll sometimes be over and sometimes be under. Then importantly, what do we do upstream? So now we are sitting with Eskom generation, which is of course super dominant in the market right now, and we are sitting with legacy stations that have already received in total probably about R500 billion of state assistance. And so what does the public interest require? The public interest requires that the stations remain available as long as the country needs them and produces the energy when we need them to do that. So the first point is most stations will be earning the S&P in the market, so that will include rent for the energy part, so they'll make a margin on the energy. What we propose is that the hedge sweeps that margin back to the central purchasing agency so that the generator earns exactly what it needs to cover its cost of production and nothing more. Then, of course, in the tariff, as already proposed, customers pay the generation capacity charge and the distributors pay that over to the central purchasing agency. However, now we get back to what does Eskom generation get paid for capacity. We only need to pay them what they need to keep the plant available, right? It's some particular power station. How much cash do they need? Well, we'll have to go and audit that to see what they need to keep the plant available, pay the salaries, do the maintenance, perhaps make some marginal capital expenditure to fix things and keep it running for however long the system operator thinks we are likely to need that plant. So there's a difference between the generation capacity charge earned from the market and the smaller amount of the availability payments made to the generator. So now the CPA in this scenario does not have a cash flow risk. It's actually sitting on money every time, every round, every year, every period. It's getting the informational rent from the generators. It's getting rent from the capacity charges for the volumes covered by these hedges, right? And then, of course, just lastly, it's also getting legacy charge payments. And in our proposal, that's only to pay for the second 34 IPP. So the CPA will be completely net. We're not showing it on the graph and diagram here, just to save space, but they'll be neutral. What comes in goes out to pay for the section 34 IPPs. So the remaining surplus that the CPA sits with is essentially the informational rent from the energy and the difference between the capacity charges from the market and what they pay the Eskom stations. And that is paid over to Eskom Holdings to assist with servicing the financing cost associated with the power stations that are covered by the hedges, right? And of course, to the extent that there are unhedged volumes, the informational rent will accrue to the actual power station, and that, of course, also flows to Eskom Holdings. This, of course, makes it very visible. We are trying to support the servicing of the debt on the Eskom Holdings balance sheet. we're not paying anything more than what we need to pay for services from the actual power stations. So this is a new insight, right? Up until now, we've regulated Eskom generation as one big blob. But actually now we have separate power stations, and the financing situation sits at the Eskom holdings level. So we can split that. We can deal explicitly with what the generators need and pay them what they need to operate. And we can address the financing issues directly at the Eskom holdings level. Here's the fuller picture, and much more details are included in our submission to NERSA on our website. Of course, we don't have time to go through it today. So just two last slides, Mr. Chair. A few other considerations not addressed in our submission, and we can't cover in detail today, and other stakeholders have also addressed this. Capacity and ancillary service costs are covered twice. There's a mismatch between the upstream and the downstream hedges, which creates this growing residual that then ultimately results in a recursive reduction of the wholesale tariff energy charge. And this creates inter-period cash flow risk for the CPA, which is the last thing that we need, because the financial integrity of the system must be absolutely beyond question. Further, market power remains unconstrained because Eskom is nothing in the regulations or in the proposal says that they must put their capacity into the market. So we're proposing that they should not be able to withhold capacity to artificially inflate market prices. If they want to be paid for capacity, the energy needs to be bid into the market. This is a very important point. Also, we haven't discussed this much in our short presentation today, but the Energy Council colleagues did mention it a bit more. But the energy offer regulation, that's a separate issue. That's how they bid into the market. That must, of course, be short-term marginal cost. The details for how that should be regulated needs much closer scrutiny. And we think that every station short-term marginal cost should be independently audited by proper independent auditors. And then maybe two last points here, the monitoring issue, and it came up also in previous presentations, is kind of expressed as may. The NERSA may monitor this or may require this. This is a critical issue when we're now introducing this reform. Many stakeholders stand ready to assist NERSA and help do analysis and reveal more information to help us deal with this information asymmetry problem that Ms. Massetti was talking about. So we suggest that the requirements, the license condition requirements for substantial aggressive information disclosure at a power station level and at any other level required should be built in from the start, so that our risks of getting things wrong are dramatically reduced. And we also ask that the vesting contracts, when they're finally drafted, are published for further comment. So lastly, Chair, my concluding slide. What we are arguing is that merely patching the current proposal will not work, because essentially it's still based on the legacy paradigm. And the defects with respect to how it functions in this new transition world we're going into arise from using the wrong paradigm. The remedy is to change the basis of tariff and vesting construction, not to merely adjust the drafting. The market proxy approach offers a design for vesting contracts that works with the market rather than against it, along similar sentiment as expressed by colleagues from the Energy Council. And critically, this approach is implementable in vesting contracts from day one. But continued reliance on the MYPD is not implementable, as we argued. This approach, the market proxy approach, will relieve NERSA of this untenable position that they're currently placed in, where they have a methodology that they can't actually properly implement. And it removes the need for high impact regulatory discretion, which that has no methodological basis. For instance, how you have to choose about what WACC you actually use when there's no basis for doing it other than the actual real opportunity cost of capital. We completely move away from that approach, where you have to make these huge discretionary decisions. This approach is therefore far more defensible against legal challenges, because it rests on objective market proxy information and ultimately actual market information and cost evidence rather than just judgment. It keeps the stranded finance cost recovery visible and separate rather than buried in a kind of a regulatory asset-based return-based energy price. So critically, if you stand back and look at all the debates we currently hear in the public domain, including, of course, the issues we're discussing today, is that we need to get the order of priorities right. We should not be putting the cart before the horse. Clearly and explicitly stated, the people of South Africa and its economy are not there to serve Eskom, right? Eskom is there to serve us, to serve them. Every design choice in the SOLWEM, including the vesting in the wholesale tariff framework, should be tested against that order of priority. Consumers first, then the market, and then the incumbent's balance sheet. I'll ask, therefore, Chair, is that NERSA adopt the market proxy approach as a basis for vesting contract design, including separating out the legacy debt payments as a direct transfer to Eskom Holdings and not through a kind of a opaque regulatory formula. Thank you very much.
I will now give the opportunity to members if they've got any questions for Dr. Steyn. I will start with Madam Maseti.
Thank you very much, Dr. Steyn, for the presentation. It's a pity that we don't have the luxury of time so that we can engage on a number of things, but I would assume that some of the questions that we've asked previously, you will touch on them, especially the one on the strike price. I would like you to touch on that. And then the second one is on the differences that arise from the upstream as well as the downstream, as to, first of all, just to, ascertain who will benefit from that difference that is occurring or that is likely to occur between the upstream and downstream. And then linked to that, how do we then sort of try and ameliorate that the asymmetry that could arise? How do we ameliorate that? And then thirdly, how do we protect consumers from such a difference that might ultimately be paid by consumers? I would like you to have some reflection on that, on the strike price first, and then on the asymmetry relating to upstream and downstream in respect of those three aspects. And then you made mention on, I think there's a statement that you made with regards to scarcity, that the price must focus, what is it? I'm trying to check the notes here. Yes. You said the price must, where's that statement? But you said the price must follow scarcity or must be based on scarcity as opposed to sunk cost. You made mention of that. I was a bit, I am a bit concerned about that. And the reason for my concern is that maybe you need to clarify the scarcity that you are referring to, because if it's high scarcity, then there will be a problem. But if it is efficient scarcity, then we will be talking about something else, and we need to just clarify that efficient scarcity, because yes, we are very much interested in ensuring that we facilitate investment and attract investment through the price. So if it's just scarcity, there are practical and factual issues. If the price needs to give a signal of high scarcity, maybe you need to just clarify that aspect for me. And then there's just a last point that I wanted to, how do we until again on the scarcity issue, how do we establish that a scarcity price reflects genuine system scarcity rather than the exercise of market power by the supplier. I think for me, that question is also very important, just to assist us as NERSA, as we have this mandate of making sure that we curtail market power. That is our primary objective. So in this case, when we deal with scarcity and in ensuring that that scarcity, that must be a signal, must be an efficient scarcity, not a high price scarcity for signal. So that for us is quite important. But the question again is, how do we then establish a scarcity price that reflects genuine system scarcity rather than the exercise of market power? And then the last point that I would like to touch on, no, I think I've already dealt with it, how we avoid that asymmetry and protect consumers on the upstream and downstream. Thank you very much, Chairperson.
Thank you, Madam Masedi. I now call upon Mr. Mkize.
Thanks, Chairperson. Thanks, Dr. Stein. I'm covered. I just would like to just step into one issue. If you have put a jet or other socio-economic imperative overlay into your model as presented, I would like to just to understand that the issue of just energy transition as well as socio-economic imperatives. Thank you.
Thank you, Mr. Mkize. And then call upon Advocate Litole.
Thank you, Chairperson, for the opportunity, and thanks to Dr. Stein for his presentation. I just have one point of clarity. In one of his slides, he talked about monitoring being made discretionary due to the use of the word may. And I just wanted to find out from him if he has any proposal as to how we can make this mandatory, because I did not pick that up in his presentation. Unless if I've missed it, I apologize. But if he can clarify that for me, I'll appreciate it. Thank you.
Thank you, Advocate Litole. I am now going to call upon Dr. Stein to respond.
Thank you, Chair, and thank you to members for their questions, which are very pertinent. And I'm going to try my best to give you a response. I'm going to start from the top, Ms. Maseti. So the strike price, and I presume you're referring primarily to the upstream hedge with the Eskom power stations in the NERSA proposal, and then downstream, and then maybe comparing that to what we're proposing. So yes, I mean, our understanding is that the energy, the upstream price will essentially be based on the current NYPD methodology, right? And the details are also reflected in those graphs, or the diagram, sorry, that we showed you. And that means that even though the stations bid at the short-term marginal costs to help the SAWEM function, they actually get paid and retain a higher price, except for the marginal station. And of course, then the problem downstream is that particularly that the wholesale energy charge is calculated. Well, the total calculation is essentially also based on the allowable revenue you currently use, but you deduct, to get to the energy part, you deduct all the other charges, including the legacy charge first, and that is the wholesale energy charge, and that's to customers, and it's also the strike price for the downstream hedge. And essentially that energy price will be a different strike price to what you're paying the generator upstream. And that's just as part of what creates all these problems with the current proposal. So of course, what we are saying is we're trying to propose a much simpler, cleaner approach, which takes away all the risk to the CPA, because we can't have the CPA sitting in the middle with no actual balance sheet and having cash flow mismatches. And it also, so what we're saying is, when we look at Eskom, we don't just see one big generation blob anymore. We now see separate power stations, and the hedges are with those individual power stations, right? And then you've got Eskom Holdings with its balance sheet and the capital structure separate or higher up in the structure. And we're proposing dealing with those things separately for each one of them, giving them what they need, right? So we say at the power station level, we need two things. We need the station needs to be available, right? So it can run because that's what the country needs. So pay it what it needs to continue staying available. So that's the incremental availability cost. That can be audited, right? It's an empirical question. We can go and find out what those costs are. Secondly, the energy cost, the net effect after the hedge should be that we just pay them the marginal cost because they don't need anything more at that level. They just need to pay the fuel and the operating cost and the maintenance and all of those things. Well, that's so the hedge should bring us, so they should bid their short-term marginal cost for energy. They could pay the system marginal price, which for most of them will be higher than their bid. Then we should hedge them back to their short-term marginal cost because that's all they need. So we take that margin back to the CPA, which of course will be paid over to Eskom Holdings, which is where it is needed. So that's on the upstream side, that's what we propose. And then we say downstream, let's try in now customers. So I mean, ultimately, if you think about it, every power station generates or they earn the system marginal price, right? So and they make inframarginal rent. So customers will be paying it on the other side, right? They'll pay the inframarginal rent. But the and that's why we're saying that the wholesale tariff should be based on the forecast of the SMP, because you have to set the tariff obviously in advance of the actual real-time market. And the hedge will just correct the forecast errors, the downstream hedge. But then so customers pay the SMP, but the forecast version, so they're not exposed to the volatility on an hourly or daily basis, and even unexpected stuff. You can do that on a period by period, like an annual basis. At the moment, we work with on an annual basis, and then of course, but when the revenue gets to the CPA, then that rent goes through the market to the generators, and then it's clawed back to the CPA, who pays that over to Eskom Holdings. So that's why we think that we now linking the whole thing to the market. You're not paying the power stations more than what they need, and you're paying the difference to Eskom Holdings, and also the difference between the capacity charge and what you need to pay the power station for capacity, which is less than that. That difference also gets paid over to Eskom Holdings for the vesting volumes and the vested capacity requirement, which we argue should be determined by the system operator on an annual basis, because they have the models. They're actually already doing it. They already have this medium-term system adequacy outlook model. They have a range of models they can use to actually do this. We also model this kind of thing, so we understand how it works. So I hope I addressed the first part of your question. Okay, then the second part is the issue about the price must reflect economic scarcity as opposed to average costs, right? So, of course, as a good regulator, you're always concerned about high price impact on customers, because that's we're seeing that at the moment, and it's a real crisis, right? But of course, ultimately, we would argue that economic regulators should be very concerned about efficiency, because ultimately sending everybody the right signals is how we get people to behave appropriately and get the system and the market to produce the power we need at the least cost. So this is probably the heart of any functioning market, if it works in the public interest. Of course, many markets do not work in the public interest because there's dominance, etc. But what we are aiming for, and what we have to actively pursue in the design of this system, is efficiently functioning markets. And in that situation, yes, we do want prices there. The public interest is not in regulating a price at a particular level. The public interest is to have a feedback loop, to tell the economy when we have a scarcity of power. so that the price must rise and that the system can respond. Consumers can realize, oh, hang on a bit, we've got shortage of power, we must use less, or we must make other plans, or whatever. And the investors can look at, oh, there's clearly a case for building more plants and getting more stuff online. If we have a system that works like that and works efficiently and also has the longer term price signal in the capacity auctions, we would have avoided load shedding at the level we had it before. Part of the problem with load shedding is there was no price signal. We couldn't tell people, we couldn't send a price signal to say to the economy, hang on, we're short on power, do something about it, consume less or invest in generation. There was no signal, right? And that when you ration things like that, then the system falls apart. And that's part of the reason why we had load shedding in the way we had. So we do want prices to move to reflect scarcity or basically abundance, right? End consumers, how are they affected by this? Well, of course, first of all, due to the downstream hedge and the way that it is using the wholesale tariff as a strike price, that will be protected against short-term volatility, right? But ultimately, prices will adjust and must adjust, as you know, as we all know, to reflect ultimately the resource, the scarcity of the resource, and ultimately so on an annual basis, and hopefully in future on a more regular basis, prices will have to adjust. So let me just say one small further point. Of course, for residential and particularly poor consumers, the total cost of supplying poor consumers energy, the energy price, the wholesale energy price, and the capacity price that we're talking about here today is actually a very small part of the cost of supplying residential small users, right? Most of that cost is the downstream network costs, the vending costs, maintaining the distribution and reticulation networks, etc. So changes in the pure wholesale energy price actually has a relatively small impact on end consumers, smaller end consumers. There are many other things that are probably more important there. And sorry, let me just say one opportunity. The point about you made the point, which we had the luxury of time. I think most stakeholders would agree that we need more time. We need opportunity to engage with these other on these issues and explain them and explore them and pull them apart more clearly. So we would again just repeat the request that there would be a series of technical workshops, and that the key decision makers, the members who are involved in this, might want to consider sitting in and being part of that, because we have a very steep learning curve for all of us that we are going through here. Mr. Mkhize, your point about the JET and the socioeconomic imperative in our model. So I'm not sure whether you are referring necessarily to the downstream end consumer side, or whether you're referring to what happens to the coal plant, the upstream stations. Well, of course, both are important, right? I've partly addressed the downstream issue. We have seen enormous tariff increases over the last 15 years or longer. And ultimately, it's my understanding that that is because we just did not have appropriate risk allocation on the investment side and appropriate incentives, therefore, for efficiency. And therefore, our cost base has inflated despite regulators' best efforts. You know, once Eskom has built the stations or decided on how to go about obtaining stations and building them and taking the risks and cost overruns, time overruns, all of those issues, there's nothing really the regulator can do, because and consumers just have to pay that. Where if you have a model where investors and their financiers know upfront that they are competing and they are taking the risk, they go about this very, very differently. I spent my doctoral studies on looking at this experience in the UK and also in South Africa. So, Mr. Mkhize, upstream, of course, the key issue is the JET and the issue around the coal industry and the power stations. We did a separate study published on our website last year about the role for the coal plant to become more flexible, and it's not just the diurnal flexibility, but seasonal flexibility, etc. That is an important pathway for the coal plant. So we think this whole debate around, oh, we should extend the life of the coal or plant, or we should shut it down sooner, is actually incorrectly posed. The question is incorrectly posed. The question is, what's the pathway for the coal plant? And if we set up this hedging vesting contract and exposure to the market correctly, what you'll find is that the coal plant we will want to pay them to be available, right? People will have to be there, but they're gonna in time produce less and less and less energy as we get more cheaper energy onto the grid. So that's a much more gradual transition, and that I would say is maybe an important point, but also the implications for the socioeconomic impacts on employment. I think it's Sithole, your question about monitoring, whether I'm all concerned about it. Sounds like it's still discretionary, and how do we make this mandatory? I mean, I guess there are different ways NERSA can do this, but okay, two key points is and one of the members has already asked for that information. Is we need to really think very carefully about what the information is that should be disclosed. I mean, it should be an order of magnitude better than what we currently have. I mean, stakeholders don't know what's going on in the market. I mean, for instance, as an example, everybody knows there's a lot of curtailment happening for a renewable plant at the moment. It's gone up dramatically. There's no central picture. Nobody knows. There's no data. Nobody knows why it's happening. It's just it's a black box. That cannot be the case if we in an open competitive market. There is a significant amount of information that will have to be disclosed on an ongoing basis. How do we make it mandatory? NERSA probably has many tools that it could use. It could change the license conditions to include that for the plant. It could just make some general regulatory rule, etc. I'm not a lawyer, so maybe this is not my area of expertise, but it's clear that NERSA has many tools available to it. I think I should stop there Chair, I think I'll pause there.
Dr. Steen, I think we're going to now go on to our next presenter, Mr. Mbata. So, Mr. Mbata, please switch on your camera.
Thank you, Chair. Thank you, Chair.
And please raise. Yes, please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth?
Thank you, Chair. If I can just mention, as Meridian did mention, we do endorse their presentation and largely aligned to their submission. So we will not be having a separate submission as SAITA, but we will largely aligned with the Meridian Economics presentation and submission at this point. Thank you.
All right, thank you, Mr. Mbata, for that clarification. So if that is the case, then we are going to go on to our next presenter, Mr. Mututu from ESCOM. And Mr. Mututu, can I ask you to then please switch on your camera? And please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth?
Yes, Chair, I affirm.
Thank you. For the record, please state your name, organization, and designation.
Chair Nadim Chuchu, looking after financial planning and economic regulation at ESCOM. Thanks, Chair.
Thank you, sir. Please remember to forward your presentation to publichearings@nersa.org.za. You may proceed with your presentation. You have 15 minutes. Thank you, sir.
Chair, we've got two other presenters that will be assisting with this presentation, Chair.
All right. Can I then ask each presenter, first of all, to switch on their cameras and then just tell us who's the next presenter, just the name of the next presenter?
The next presenter, ma'am, is go ahead, ma'am.
Onika Rantwane, Chair.
Okay. Ma'am Randwane, may I ask that you raise your, switch on your camera and please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth?
I do.
For the record, please
Chair,
state your name.
apologies, Chair. She appears to be offside the camera. If she can come, we only see the chairs.
All right, thank you for that, Mr. Magunda. Madam Randwane, can we see your face when you are taking the oath? We need to see you on camera.
The camera is on, Chair.
We need to see you. All right, so let's do it again. Please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name, organization, and designation.
Onika Rantwani, Middle Manager in ESCOM Energy Trading Distribution. Thank you.
Thank you, ma'am. And then the name of the third presenter from ESCOM, presenter number 3, the name.
Chair, morning everyone. My name is Snehal Nagar. I look after finance for generation.
All right, Mr. Nagar, please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name, organization, and designation.
My name is Snehal Nagar, and I work at ESCOM, and I look after the finances for generation. Thanks.
Thank you. Please remember to forward your presentation to public hearings at nesa.org.za. You may proceed with your presentation. You have 15 minutes between the three of you. Thank you.
Good morning, Chair. Thank you very much. ESCOM appreciates the opportunity to be able to present its comments with regards to the vesting contracts. We have had an opportunity to review the contract, and in that respect, we would just like to commend NESA in respect of the foundational work that has gone into preparing those the vesting contract framework as it stands. I think outright, we just need to confirm our position that we support the opening of the market, the liberalization of the market. However, in respect of the current vesting contract framework, we have identified a couple of risks that we feel should be addressed prior to the implementation of the vesting contract framework. Some of which include financial sustainability in respect of the volumetric recovery of fixed costs, missing money risk, customer affordability risk, operational risk, and regulatory implementation risk. Now, these risks we will unpack in the presentation in the short time that we have. However, I think it's important to just state up front again that we have provided detailed comments that substantiate these risks in more detail. Just moving on to the next slide. Chair, what we just want to reiterate in respect of what we shared last week with regards to the wholesale tariff framework is that it's important that there's a regulatory alignment, in our view, that there's a regulatory alignment between the various regulatory instruments that exist in terms of the vesting contract with all the other ones, the existing revenue determination frameworks, the MYPD framework, and amongst others, as well as those instruments that are currently under development and those that still require to be developed. It's important that there's alignment from an upstream and a downstream perspective so that the costs are recovered appropriately and there's no mismatch from that perspective. Chair, I'll now hand over to our generation colleagues to then continue with the impact on the generation license activities. Thank you.
Thank you, Tindani. Thanks, Onika. So, Chair, I mean, there's a structural misalignment between capacity cost recognition or fixed cost recognition and the fixed cost recovery mechanism. This framework indicates that fixed costs are recovered through a volumetric tariff, and generation does not support this aspect. Excuse me. Primary energy costs are also assumed to be variable and not aligned to the underlying cost dynamics of those particular costs. Chair, what we also see here is that there's an uneconomic cost bypass or fixed cost avoidance, for a better word, is enabled and incentivized. And this is done at the self-generator level where they avoid the fixed cost of the system, but they are plugged into the system and use the system when required. And this avoidance of fixed charge, they benefit from the availability of the system, but what it also does is it increases the fixed cost to our lower LSM or the remaining consumers that are only consuming from the system. And that sort of creates a spiraling effect and a spiraling, call it cost increase, and a spiraling fixed cost recovery risk. Monica, if you go to the next slide for me, please. So what we're saying here is that the volumetric recovery mechanism does not provide for a robust, bankable revenue model, because there is a big risk that fixed costs cannot be recovered. There is also a risk, Chairperson, at the retail tariff structure, should this be done on a volumetric basis. So there's a risk that NTCSA would not recover its fixed cost. There's a risk that generation would not recover its fixed cost. And the same avoidance of fixed cost or uneconomic bypass also occurs, Chair, at the Munich level with regards to the Munich surcharge. And we need to find a solution around that surcharge as well, in implementing this particular model. The Munich debt also needs to be solved, and we need a solution around that. Chair, there's also no legacy cost recovery mechanism for Eskom for those power stations built under the Section 34 determinations, and this is inconsistent with the Section 34 IPPs. Monica, if you go to the next slide for me, please. So important, Chair, is that we need to get lender confidence, and lenders will require a very clear, robust revenue model. And this confidence that they will require, Chair, will be for the whole value chain. They will not only look at one aspect. And existing lenders to the Eskom debt book will require some level of recoverability assurance. They've signed those debt agreements under a particular revenue model. If the revenue model changes, it materially affects the agreements that were signed, or it could materially affect those revenue agreements that are signed. So, Chair, they are a very important stakeholder whose comments and concerns need to be taken into account as we embark on this journey. We have started engaging them, but the details, once we have a lot of the details, we will have to continuously engage them. But Chair, that's like we said, a very important stakeholder to concern. So, Annika, if you go to the next slide for me, please. So, Chair, generation supports the objectives of the market reform, but several issues need to be resolved in transitioning towards this. And the first thing we're saying is it's a decoupling of your recovery of your fixed costs from your energy volumes. You need to link dispatchable fixed cost recoverability to availability. I think many members have mentioned that. Ancillary services need to be recovered differently, and it needs to be recovered on the basis of the value that they provide. And Chair, we support that a robust financial modeling exercise be done for the entire value chain, so one can understand the impacts of all of these and how the mechanics will work. Annika, over to you. Thank you, Chair.
Thanks, Nel, and good morning again, Chairperson and the members of the regulator, as well as the members of the public. For the distribution comments, Chair, I will just focus mainly on the downstream aspect of the framework. And similar to the approach that we undertook with the wholesale electricity pricing methodology, I will just highlight some of the key risks, implications, and the recommended mitigation, especially considering the limited time. The first risk that we foresee with this framework, Chair, relates to the regulatory alignment and the market design risk, which is a point that we also raised during the wholesale electricity public hearing. We believe that to mitigate against this risk, because we have multiple regulatory instruments that are currently being developed, and if we don't have a clear alignment with these regulatory instruments, as well as what exists in terms of the MYPD, the RCA framework, and the current tariff determination mechanisms, we create a risk of inconsistent outcomes as well as pricing disputes, which is obviously what we don't want in terms of creating the delays in implementation of this framework. So we believe that it is necessary to align all these market reform initiatives. The second aspect, Chair, is what my colleague already touched on, which is the generation capacity cost and the related cost related to the generation capacity. The methodology, as we've already indicated, relies on the volumetric recovery of the fixed generation costs, and this can lead to an economic cost bypass and affect the consumer's affordability as well as threaten the long-term financial sustainability. So, Chair, the other risk is that we know that SAWEM is going to be an energy-only market with no capacity market, especially at the beginning of the electricity reform. Therefore, we believe that it is necessary that we have a clear capacity remuneration mechanism to address the missing money problem and to ensure that we then ensure adequate capacity for firm capacity as well as the long-term security of supply. The third point, Chair, relates to the general financial sustainability risks, and obviously now concentrating on the distributor side, which is Eskom distribution and municipalities. And this relates to the fact that, as we indicated, even in the public hearing last week, that there is uncertainty in terms of how some of the wholesale market costs and the vesting imbalances are going to be recovered through the retail tariffs. So the risks is that distributors, Eskom distribution as well as municipalities, will incur this legitimate wholesale costs from the market, but without clear wholesale to retail recovery mechanisms for them to be able to recover these costs. Therefore, we believe that it is important as part of this framework to establish that transparent revenue recovery mechanism. And I just want to explain why we focus so much on this risk. And it's because, Chair, the CPA is going to be at the center of this. And CPA is going to be contracting with the distributors to ensure that they collect, the revenue from the downstream activities. And the risk is that if distribution, let me talk about Eskom distribution in this case, is not able to recover those costs from the customers, then they will not be able to meet the obligations of the vesting contract to the CPA. And similarly, then the CPA will not be able to meet the obligations to pay the generators according to the vesting contract. So it's actually a cascading effect in terms of ensuring financial sustainability, not just for the distributors, but for the entire electricity supply industry. And then, Chair, in terms of the next risk, it relates to the settlement mechanism as well as the allocation of the vested volumes on the downstream aspect. The example that is provided in the framework, we believe that it is swapped is the other way around, because it indicates that when the market price is higher than the vesting price, the city, in this case, it would be Eskom distribution or the municipality, will pay the CPA. And we believe that this is not correct, because then it defeats the entire purpose of having the vesting contract in place. So on the right-hand side, we've included our own interpretation of how this example should work, basically indicating that where the market price is higher than the vesting price, in this case, the example stated that you are allocated for a vesting volume of 470, but the actual consumption is 480. So it's only the 10 megawatt hours that is outside the vested volume, and therefore it should only be the volume that is fully exposed to the market price. And the resultant then is that the net payment is by the CPA to the city instead of the other way around. So we request that these examples be created together with obviously the double recovery in the upstream example for NESA to correct and publish this worked examples. And it's not just the worked examples, Chair, it's also the principle which is in reverse. Then the other two risks relate to the vesting volume allocation and the CPA. I'll just combine this in the interest of time. it's not clear, for us to assess what exactly is being proposed in terms of the allocation methodology in the downstream contract. It specifies that it will be based on the total system demand, based on the MYPD determination. And the question then is, obviously, municipalities, they do not operate within an MYPD revenue determination. So, Chair, we do then recommend that we develop a clear and transparent allocation methodology, which also clarifies how the treatment of municipalities in terms of disbursed volumes will be done. The other aspect is that there is a proposal of a 5-year transition period, which we do not support because we do not understand what is the basis of that of the 5 years. And our proposal is that the reduction of the vesting volumes should be based on a clear market readiness assessment, where we've got clear conditions in terms of the retail tariff reforms to ensure that we've properly unbundled the tariffs and the risk management tools for the various municipalities instead of having a fixed 5-year transition period. And lastly, as we indicated, Chair, we believe that there is currently unclear governance and settlement arrangement for the CPA. It will be carrying, significant administration between the distributors as well as the generators, and therefore we need to have that clear CPA governance process to understand how exactly they're going to be doing the settlement, the reconciliation, and issues around the collateral and accountability mechanisms. In conclusion, Chair, I think we've indicated in both the wholesale electricity pricing methodology and in this framework that we do not support it in its current form. There are material risks that needs to be resolved, and we believe that this can be done through a technical work group. So we humbly request the regulator to establish a technical work group that will comprise all the relevant stakeholders, including the industry experts, to help support the development of this revised working draft of the framework. And this collaborative and coordinated approach, Chair, is not new to South Africa. We've done a similar processes with, for example, the development of the various grid codes, where there's the industry expert teams that will sit together to run through multiple workshops to develop these codes for the country. So we believe a similar approach will be necessary because NERSA, we do support the objectives in this framework in terms of the security of supply, consumer protection, investor confidence, and financial sustainability. But the framework in its current form goes against those objectives, and therefore we believe that we need to further develop it. Thank you, Chair.
Thank you, Team ESCOM. I will now give over to the members if they've got any questions for ESCOM. Over to you, members. And I'll start with Mr. Mkhize.
Thanks, Chairperson, and thanks to Team ESCOM for the presentation. I note the issue of requiring the technical work group, very much understood in the context of the challenge ahead. I would appreciate maybe if in their own view, ESCOM could also provide how they see this program panning out to the end with timelines and maybe key thresholds, as well as milestones achieved. With that, I think it will assist then that they provide comments, even on the comments that have been provided by other presenters, so that there can be, more of a discourse that critically looks at what has been, at all these comments and proposals leading to the workshops that they are alluding to, And I think that the same as Meridian alluded to, where I think that is going to be very important in terms of, making sure that those workshops are efficiently run and kept to the minimum towards getting to the framework being finalized. I would also appreciate, so I think that with that, then they can make that submission, the written submission to that effect, including other issues maybe that they might not be able to cover here or seek to augment for submission to the energy regulator. And second thing is that it's a separate, if they can just separate this fixed recovery mechanism, one, considering the transition period, and then two, with SAWEM in full swing, just to understand how the treatment of this fixed cost and the recovery thereof should be overseen. And then regarding the 5-year transition, I'd just like to get your ESCOM's reflection, because my understanding was that we have the 5-year, but the periodic or annual reviews that will then be able to see how to map the way forward and make adjustments where required. And I thought maybe even in those technical engagements, there would be some kind of further details being threshed out to the extent that a more realistic timeline could also emanate based on the technical discussions and how long as some of these things can really be put to bed. But I take it that even then, there will still be a need to periodically review progress in line with the envisaged milestones and also the adjustments that need to be done to get to a full swing SAWEM. I'll leave it at that, Chairperson. Thank you.
Thank you, Mr. Mkhize. And then I'm going to call upon Madam Maseti.
Thank you very much, Chairperson, for the opportunity, and thanks to Team ESCOM for the presentation. I just want to get clarification, first of all, around the economic rationale of the exercise that we are doing. I think it's very important that we get the principles right. What is it that we are trying to do here with this proposed vesting contract framework? So I would like ESCOM to share its understanding of what the vesting contract seeks to achieve or to manage. As from our side, it is a tool that is being used to deal with any sort of consequences of the transition. So I will just simplify it as that. Now, my question is ESCOM expecting that in the design of the vesting, that it should be guaranteed of a revenue, all total revenue, as well as the recovery of sunk cost. And this is important because it also links up with the fixed cost recovery concern. And that fixed cost recovery concern, it must also be looked into from the lens of inefficiencies or inefficient cost. Does it mean that ESCOM expects that it recovers, all the cost, like the cost of associated with each power station? Let me put it like that as an example. Does it expect that it must, or this framework must allow ESCOM to recover all its cost associated with its assets or the power stations, irrespective of ensuring efficient cost, availability, performance, and so forth. So that for me is very critical, so that we can establish the principles around this vesting contract framework, what it seeks to do, and also to differentiate it from the risk that might arise in the future, of which risk are not associated with or are not as a result of the transition to the competitive market or to the to hedged prices. So we need to draw that distinction so that we are all on the same page, and also fully appreciate the concerns that Eskom is raising. And having said that, it will also be important that we get an understanding in your response whether you are expecting the framework to be designed such that Eskom is protected from future competition risk, for instance. And hence I said that let's just make sure that if the vesting contract has to do and to deal with the consequences of the transition, that is the scope. But the vesting contract approach is not one that is designed to allow the recovery of inefficient cost, as well as to protect any entity from future competition. So they need to just make sure that they are aware of that distinction. So hence I would like to get this from Eskom. So that is the first thing. And having touched again on this issue of the asset by asset analysis, I think for me it will be important also just to carefully think about the test that might be applied, and maybe the key components of that test, because we can have key components of that test when it comes to those assets, generation assets, so that when we look into prudency as well as efficiency per power station or per plant, at least it is transparent in terms of performance, so that no one is going to have to pay for benefits that were never derived, and only because the assets exist, but the assets do not perform for the benefit of the market and consumers. So there is that aspect that I would like you to also just weigh in on, that in terms of the test or the criteria that might be used, in terms of and that must be a transparent criteria that everybody must know, and what specific factors it will consider to make sure that inefficient and imprudent costs are not going to be included or recovered. Now, let me understand the issue of why Eskom is concerned about linking the volume, the issue of the volume risk incentive issue. Why is Eskom concerned about that? I just want to understand that. And I think also it's important, as much as you have to consider your economic interest and also for the survival in the market, that the duty from the demand side, the customers that you serve, that NERSA is also responsible to balance the economic interest from the demand side. So can you, in your response, then be able to assist us in appreciating your concern, but appreciating it, you must at least show how the balance will be exercised by NERSA, as NERSA is required to undertake that inquiry and regulatory diligence. The other point, Chairperson, that I believe is very important is around the concern raised by Eskom on bankability. Let us also just understand that, or maybe Eskom just can clarify this aspect of bankability, because one would expect that bankability should be forward-looking and not a guarantee of all historical cost, irrespective of the other factors that I've mentioned, inefficiencies and so forth. So what is Eskom's view on this aspect, that bankability should be forward-looking and that there should be no guarantee of all historical costs, except those that Eskom would not have expected, and they are as a result of the consequences of the transition. That's what I would like Chairperson to ask. I'm hoping that I've covered, even if some of the issues the issues are dealt with in writing, Chairperson, because we do not have sufficient time. We would have wanted to sort of engage on other aspects so that Eskom can even submit in the next 7 days additional information in respect of the of the questions that we have asked. If I may ask just the last question, Chair, in terms of what Eskom considers to be the objectively relevant difference that justifies protecting a Section 34 generator from a market risk, that is equivalent merchant generator, which the cost that it should bear or be exposed to when it enters the market. What is the sort of relevant difference that justifies the protection of the Section 34? I would like a Chairperson to stop there for now. I'm hoping that it's unfortunate that at this point from our side, we won't have another opportunity through the workshops. It will be the technical team, but hoping that we might have another round once some of the issues have been improved, strengthened, and enhanced. Thank you, Chairperson.
Thank you, Madam Maseki. I will now call upon Mr. Sibanda.
Thank you, Chair, and thank you to Eskom. Just quickly, maybe if you can just explain why you think that components of primary energy shouldn't be variable, and be specific perhaps and give examples, because you seem to be having concerns with the classification of primary energy as constituting all variable costs. And then secondly, you indicated that there is no clarity around revenue assurance mechanism. And my question is Eskom not calling for the maintenance of the status quo here, or perhaps maybe just explain what is the intention around revenue assurance? And then thirdly, you identified about 3 decision gates, and I would want to believe that we are probably still at decision gate 1 around design issues. But you also mentioned concerns around coherence with various other components, such as the the market code, the MYPD, the RCAs, the retail pricing, and so forth and so on. Don't you think that perhaps pulling all this together belongs down the line, perhaps in further gates, whilst at this stage we are still at design phase? Perhaps that's a bit rushing the process. If you can just maybe comment on that. And then I'd like to hear your views on the proxy market alternative as proposed by Meridian Economics. And I'm sure you've raised various concerns around the framework and the fact that you don't support it in its current form. So what are your views regarding the proxy market as an alternative, as proposed by Meridian Economics? And then there has been concerns of market power abuse as we transition into a competitive market. Excuse me. What's Eskom's view around that? The risk of the dominant player, which is Eskom, abusing its market power during the transition. And then lastly, you also identified a risk regarding the generation capacity cost recovery. And as part of your mitigation, you say that we need to ensure that fixed generation and stranded costs are recovered through capacity-based mechanisms. I thought that was part of the framework. Maybe if you can clarify further, what is it that is missing in the framework as it is currently designed? Thank you, Chair.
Thank you, Mr. Sibanda. I will now give opportunity to Eskom to respond to the issues raised by members. Over to you, Eskom.
Thank you very much, Chair. I will take the first 3 questions and then hand over to my colleagues to deal with the rest of the questions. But Chair, I do agree that we will also provide written submissions for some of the questions. So maybe just to take question 2 from Mr. Mkize in terms of the fixed cost recovery and how we believe that the treatment of this should be dealt with within SAWAM. Chair, the principle that we are alluding to in our inputs is the principle of transparency, unbundling, as well as cost reflectiveness, where we ensure that the costs are recovered in terms of their cost drivers. So as we indicated, and this touches on this last question that was asked by Mr. Sibanda in terms of the capacity cost. You are correct. In terms of the wholesale electricity pricing methodology, the principle aligns with what we believe should be the recovery of the generation capacity costs. However, in the vesting contract framework itself, then the same fixed capacity costs are going to be recovered on a volumetric basis, and that is the key risk that we want to highlight, Chair. The second question around the 5-year transition period with annual review, I just want to clarify that we are not against the periodic review. In fact, this is supported to ensure that we periodically review the transition and what has been vested in terms of the volume allocation in the vesting contract. What we are not in support of at this point, Chair, is that the 5-year cannot be fixed to say that after 5 years, then there won't be a vesting contract without a proper modeling and assessment of the readiness, market readiness, including whether there is capability in terms of the systems, whether the tariffs themselves are properly unbundled, and the operational readiness before we can then expose the full volumes of distributors to the market. So we are not against the annual reviews, We just do not support the fixing of the 5 years at this stage without the proper market modeling. And then just the last question that I want to touch on, because the rest are basically related to generation, is what was asked by Ms. Masetti in terms of the ESCOM expectation to be protected from the transition. Chair, I don't think that is the intention of ESCOM, and that is not the intention of this market. We understand that there are embedded risks with the market. There is volatility in terms of the costs. What we are requesting, and what in terms of also ensuring that we protect the customers, because that was also mentioned, is to ensure that we correct the current signal, which is incorrect, and the unfair crosses subsidization, which is currently happening, where the poor customers end up subsidizing the customers who are able to then leave and purchase energy from the market or from other private generators or traders. So that is what we are asking for, to say that let us unbundle the tariffs, because that is the key issue, that we ensure that the costs that are fixed in nature are not recovered on a volumetric basis, because it introduces then the cost recovery risks and goes against the principle of cost reflectivity as well as the transparency. Chair, I will stop there and then hand over to my colleagues to also maybe pick on some of the questions that they would want to address. Thanks.
Thanks, Monica. Chair, just in respect of the balance of the questions, yeah, would appreciate an opportunity to be able to respond in writing in detail to those comments, Chair. Thanks.
Thank you, Team ESCOM. So we will await your further written responses to the questions posed by members. So on that note, we are going to go to our next presenters from the Energy Intensive Users Group. It's 3 people. So let me start with Mr. Mondi. Mr. Mondi, can I ask you to switch on your camera and then raise your right hand and affirm the following. You solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth.
Yes, I do, Chair.
For the record, please state your name, organization, and designation.
Chair, my name is Fanele Mondi. I'm the CEO of Energy Intensive Users Group. Thank you, Chair.
Thank you. And I see the next presenter in the team is Mr. Machia Nzimbi. Can I ask you, sir, to switch on your camera and raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth?
Chair, I do not think he's with us. He had a commitment at 12, and so is Dr. Nick Dawson. So maybe we can proceed. I will do the presentation.
Thank you, Mr. Mondi. So please remember to forward your presentation to publichearings@nesa.org.za. You may proceed with your presentation, and we have 15 minutes. Thank you, sir.
Thank you, Chair. Can I confirm if my presentation is showing on your side?
We can see it. Thank you.
Thank you, Chair. I'll just go straight to the purpose of the presentation. Chair, thanks for the opportunity to present our views on this framework. As the IUG, we support the broad direction of reform generally towards a competitive wholesale electricity market under the SAWEM architecture. However, we emphasize that implementation must be conditional on readiness and enforceable governance safeguards. In this presentation, Chair, we will try to cover the pros and cons of this framework
the positive and negative impacts on our members, as well as what we consider to be the gaps either in the framework or its potential execution, as well as what we propose as recommendations for NERSA. Chair, starting with the overall position, we believe EIUG, like I indicated, supports the broad direction of electricity market reform. We support separation of fixed costs, ancillary services, SRMC-based energy offers, the strike price benchmarking, and the vesting contracts. However, we do not support implementation until the market has a bankable settlement, collateral, default management, and readiness framework, which we believe are the gaps in this framework, Chair. The proposed architecture stabilizes prices, but does not adequately identify who underwrites cash flow, timing gaps, municipal default, market operator liquidity, or institutional non-readiness, Chair. EIUG's position is therefore conditional. Reform must proceed only once readiness gates are passed, settlement systems are tested, and governance safeguards are enforceable. With regards to the strengths of the framework, Chair, I'm not going to go into details. We accept the need for the structural separation, the revenue stabilization, benchmarking transparency, consumer protection, market oversight. However, we believe that robust implementation and proper benchmarking and transparency will be critical for these strengths to be realized. A number of presenters today, Chair, have covered intricate details on how best to deal with benchmarking and transparency, which as EIUG we are not covering on this presentation, but we certainly broadly support. In terms of what we consider to be weaknesses and risks, Chair, it's about the settlement risk. There is no clarity of who finds timing mismatches between upstream settlement and downstream municipal payments. I think in part that is what ESCOM was also covering. We are concerned about the matter of municipal areas, weak payment discipline risk being transferred into the wholesale market. The 100% vesting exposure, we think it's a non-starter, Chair. I think I had Madam Masete talking about those or similar risks earlier on. I think it was on the first presentation. We do not support a high vesting exposure, Chair. Institutional readiness gaps. We are concerned about the readiness of all the players, starting with ESCOM. I think we already heard what they are saying, and TCSA, we are yet to hear their own readiness. We think municipalities are not ready, and we also think NERSA may not be ready for this in terms of the systems as well as the enforcement capacity. The market distortions, these are high vesting volumes, or rather high vesting volumes are likely to suppress liquidity, delay price recovery, and reduce incentives for new entrants. Regarding the implications for energy intensive consumers, we believe the positive are a potential of price stability, predictability, as well as efficiency incentives. The negatives, however, are around the hidden credit risks. We think industrial or compliant consumers may indirectly find themselves underwriting municipal non-payment through some sorts of legacy charges. Liquidity suppression. With the high vesting volumes, we think this is a real risk. Unclear settlement rules, risk of cash flow gaps affecting generators and large customers. We think this is quite crucial. I think ESCOM also touched on this one. Delayed competition, prolonged vesting contracts could entrench ESCOM dominance and slow retail market opening. I think a number of other stakeholders have touched on that risk, Chair. The gaps, we think it's about the absence of a settlement, collateral and default code, which deals with timing, collaterals, dispute rules, etc. undefined municipal readiness criteria, billing, metering areas, as well as general discipline. Unclear CPA funding status, sovereign-backed or participant-funded. We think that has not been touched at all, how that's going to work, Chair. Missing scenario testing. We believe that the liquidity stress, municipal default, and fuel shocks are not adequately covered. I must just add, I think Eskom touched on this, some of the examples, as we were reading the examples, also we had a challenge internalizing them, Chair. I think there is a need to really revisit the current scenarios that have been presented. Unclear NESA capacity around surveillance, enforcement, and staffing. I already spoke to that, as well as the lack of customer education and dispute resolution framework. We think there is a whole lot of work that needs to be done in that respect, Chair, before we can go to implementation. What we recommend, therefore, is that NESA publish and enforce a settlement, collateral, and default code before go live. That is missing as far as we're concerned on this code. Phase implementation with readiness gates across Eskom and TCA, municipalities and NESA. We think that a phased implementation roadmap may be of assistance, Chair. Limit vesting volumes, we think that should be, in our view, between 60 and 70 initially, with some automatic reduction triggers linked to the market liquidity, as well as non-Eskom participation in the market as it grows. Define CPI obligations around funding, collateral, default rights, as well as government backing if so required or so determined. Require municipal certification, especially with regards to financial and metering readiness before participation. The way the code is written, it sounds as if it's just a matter of choice. If the municipality wants to buy from Eskom or go directly, to the CPA. Establish a default fund and collateral requirements for all participants. Conduct stress tests for liquidity, arrears, and market manipulation scenarios. Publish national surveillance readiness plan around staffing, systems, and enforcement powers. And we believe that there is a need to set hard sunset dates for vesting contract to avoid prolonged distortions. I think that has been quite covered fairly during the course of this public hearing. I spoke to the need to educate customers. In closing, Chair, we believe that the transitional generation pricing and vesting contract framework is directionally sound, but implementation without enforceable settlement, collateral, and default safeguards would expose the market to significant financial and operational risks. EIUG urges NESA to conditionally approve on readiness gates, enforceable governance, and transparent risk allocation. We believe that reform must be phased, bankable, and credible to protect consumers, support investment, and ensure stable transition towards competitive electricity markets. Chair, there is a point which has been coming up quite strongly, I think, both in the last WEB's public hearing as well as today, the need for further workshops and discussion as EIUG. We stand ready to engage in such to ensure that Transitional framework is credible and supportive of South Africa's industrial competitiveness. We believe that such workshops will really help all stakeholders to converge on common views, as well as expose clearly where we have disagreements. And by so doing, NESA is in a better position to make a decision. I think there is a lot of learning, certainly on my side, I've done throughout this session on things which I better understand now, and some which probably I need to do more work for me to better understand, but it is purely because of sharing of these ideas, which I think a workshop setup is really a good starting point. Thank you, Chair.
Thank you, Mr. Mondi. I will now give this opportunity to the members of the regulator if they've got any questions for Mr. Mondi. And I will start with Mr. Mkize.
Thanks, Chairperson, and thanks, Mr. Mondi. From my side, it's not necessarily a question, but maybe to firstly being grateful to Mondi for the presentation and as a representative of other entities. I think we'd appreciate if you can maybe zoom into specific recommendations. The general guidelines or principles that you're highlighting as needing to be put in place are highly appreciated. But zooming into specifics, for example, the funding mechanism for central purchasing unit, how do you think that the CPA, the mechanism around its funding should look like? You know, even if there are certain milestones or phases, just to kind of outline those to help now in terms of taking this to some finality, because I appreciate all the presenters raising the need for further workshops or technical engagements, but even then those must be done with a program plan so that we can do that with us having a view in terms of where we see the end being reached. So if you can just assist in that regard. And I think that by just thinking along those lines, it will also help in terms of playing a significant role in those workshops by coming up with those specific recommendations. That is all from my side, being grateful also of your presentation. Thank you.
Thank you, Mr. Mkize. I will now call upon Mr. Sibanda.
Thank you, Chair. Thank you, Mr. Mondi. Just one question from my side. There seems to be tension between your proposal of a hard sunset date for vesting contracts and an approach that's probably a bit fluid and is dependent on market maturity. You would have heard ESCOM saying that they are not supportive of a fixed date, and they would rather would rather perhaps look at whether the market is ready to do away with the vesting contract. Do you think that there is some middle ground, perhaps, because your suggestion says hard sunset date, ESCOM says no, and a few others also have proposed perhaps that we look at particular triggers. Do you think that there is some middle ground there, and if there is, what would those be? Thank you.
Thank you, Mr. Sibanda. And now I call upon Madam Maseti.
Thank you, Chairperson, and thanks to Mr. Mondi for the presentation. I just would like to start off on the question that deals with a possible decline in industrial volumes, and as a result, then the socialization of the cost. So what I would then ask specifically is whether vesting framework should protect only price risk, or it should also protect the volume risk or deal with volume risk. I note the point that you made, which was the question that I asked of that high percentage of 80%, right, initially. I just note that, but all that I want to find out from you is whether the purpose of the vesting should, in terms of scope, should only protect price risk or also a volume risk. And therefore, if then industrial demands fall, who should then bear the resulting under recovery? And that's really that issue around the socialization and the decline in volumes. Then I go to the key messages towards the end of your presentation, where you mentioned the fair risk allocation. With regards to that, I would like to find out then what do you believe is the strike price method or approach that you support? For instance, I mean, there's a lot of things that have been said, as I indicated, that in the framework, there's that issue of cost reflectivity or cost reflective, and ESCOM earlier on mentioned cost reflectivity, but I also mentioned issues of inefficiencies of cost. So does it mean that for as long as the cost is incurred, it must be, it must be recovered or be compensated? So what I would like to find out then is from EUG, what strike price would you support? And therefore, should the contract for differences be fully, symmetrical when the system marginal pricing exceeds the strike? And that really, I'm trying to deal with, pin you to that issue of the fair risk allocation that you've mentioned, now linking it and aligning it with a potential reality that could arise. So hence I'm asking that question around the strike price, what your views are, and whether then the difference must be fully the difference, how the difference there should be dealt with if it exceeds the strike price. Then I would like to go to let me go to the question around legacy charges. Which costs should legitimately qualify for the legacy charges? I recall even last week, some stakeholders have indicated that there are certain costs that should not form part of the legacy charges. And there was also an issue of the stranded assets and the cost that are associated with that. But here I would like to find out, for purposes of defining the scope or the legacy boundaries here, because the vesting itself, it has to deal with just the consequences of the transition and the historical issues on that, and nothing more. So it's important also for legacy purposes and the obligations on the part of ESCOM that we define this properly. So my question is therefore, what should qualify for the legacy charge, and what costs should be expressly prohibited and should not be included in the legacy charge? The last question, Chairperson, and I need to ask this one in terms of the Section 34, because it has not been dealt with even last week extensively, so that we get a clear sort of direction from stakeholders, how they feel about this issue of the Section 34. If I were to put the question to you as to how do you believe Section 34 IPP obligations should be treated, where the PPA, for instance, the PPA cost exceeds sour market value pricing, how it should be treated, the Section 34 IPP obligations. And should that difference then be legacy or policy cost or CPA exposure or something else. I think this is very important for us because there might be an important action to prevent policy cost from contaminating competitive wholesale pricing. So if you got the gist of the question, I would like you to, even if you are going to do it in writing, but I think it's very important as to how we treat those Section 34 and the issue of a certain risk arising from that, and also our mandate and the workable competition, not necessarily from that effective competition that we're going to see, but workable competitive wholesale prices. Thank you very much.
Thank you, Madam Maseki. So, Mr. Mondi, can I then give you an opportunity to respond?
Yes, thank you, Chair. Thank you, Commissioners, for the questions. I will start with Mr. Mkiza's question. I think on the recommendations, I presume, Mr. Mkiza, this is probably one which you will expect to be well thought out and probably presented either in a workshop format or written format. So at this point, I don't have an answer. All we were trying to do was to point on some of the things we think are the gaps which NERSA should consider. My sense is that we will probably not provide a method, but probably provide pointers on things which we think may be considered, because we as an association, we do not have the expertise nor the resources to do this kind of work, but we are, as part of this engagement, we believe that it is our role to point NERSA on some of the things that may need to be considered. Regarding the issue of the Mr. Sbanda's question on market readiness versus sunset dates, this is I think the question was, is there a middle ground? And my answer is de facto yes. We think both are necessary. The danger of using only market readiness is that it can go on perpetually without a target in terms of when do we get there. So my sense is that there needs to be both, where we say that, okay, this is what we believe this should take. If we say that it's 5 years and then we time it to say that on year 1, this is the level of readiness we expect, and year 2, etc. But to just simply say that we will go along and monitor as matters go, we think that is probably a little bit risky. It may, I mean, we've got a number of similar cases in our, policy environment where a decision is made to say something has got to be done, but because there is no time frame, it just keeps on delaying, and eventually some of them have never been implemented as a result. So it is in that context where we say that there must be some kind of convergence on when we want this thing done. So yes, there is a need for a middle ground. Regarding Ms. Maseti's question, I think there is quite a number of them. I think the first one is really about the industrial decline, as well as the associated socialization volume risk. We have not really got into detail in terms of dealing with that. So at this one, I will think that it all depends on how the market performs. We believe that the vesting contract, other than the volume and the price risk, it's about predictability. I think for the industrial users, one of the key measures is to say we have the predictability. 2 is that we can manage volatility. I think those are the 2 key killers of industrial volumes, over and above, obviously, the actual price. If they become high, as we know currently, a number of our members are undergoing quite a strain. So we think on that basis, we are supporting this if it provides for such. But should it decline, how should it be socialized? I think that's the only way, because the costs have got to be incurred. It would mean that a lot of other consumers have got to close the gap. Unfortunately, I certainly don't have a position right now in terms of how that can be done, but it's something I will take it back to our members and colleagues and see how best we can answer this question, Chair. Regarding the matters of the strike price, the strike price, the way it is defined in the document, it's really at a principle level, in my view. And I think a number of stakeholders here have gone into details in terms of some of the potential weaknesses that may come with the strike price. My own observation as I was going through the paper was the sense that, in theory, if the strike price is benchmarked as the principles stipulate, then we shouldn't be having this challenge. So it's a matter of benchmarking the correct what do you call it, a strike price. I think we talk about the need to bring in the technology, etc. We also talk about the marginal efficiency. I think the marginal efficiency specifically is something that needs to be closely monitored, because if we have to use it for let's say if this transition takes 5 years and we use the same value, probably we'll be defeating the purpose. So we can use that marginal efficiency to adjust, the striking price to be reflective of a competitive environment. So I think that's one way of doing it. But more importantly is to make sure that the benchmark itself is closely related to what it is trying to mimic in terms of the market. I think a number of stakeholders spoke to that, and I think that's the answer I can provide for now. Regarding the inefficiency recovery, we definitely do not support that. We think part of the reason we want to go to the competitive market is that Eskom must compete with others without bringing their inefficiencies into the recovery mechanism. Over the last few years, or actually not few, many years of MYPD, we have seen those inefficiencies reflecting, especially on the RCA, which has been a pain point for our members, because despite the potential ability of the MYPD to stabilize prices, with the RCA changes which happen year after year, it just failed to deliver in terms of that predictability and price stability. So we certainly think that Eskom has got to work on their inefficiencies. It cannot be expected that the consumers should pay for that. The legacy charges and Section 34, I will combine that. But Chair, we will also try to expand on this, maybe either in a workshop or in a written format. But in my view, Section 34 probably should be part of the legacy costs. That is, if the policy is not able to take it, but I think it will certainly fit into that. What other legacy charges can be put in there? I don't have an answer at the moment, Chair. Thank you.
Thank you, Mr. Mondi. We are now going to go to our next presenter from the National Transmission Company of South Africa, Mr. Etzinger. So, Mr. Etzinger, may I ask you to switch on your camera?
Good day, Chair. Unfortunately, Mr. Etzinger has a conflicting commitment, so I will be presenting on behalf of NTCSA.
Okay, and maybe your name?
It's Kamini Mudli.
All right. Thank you. So, Madam Mudli, may I ask you then to switch on your camera and also to raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before the panel is the truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name, organization, and designation.
Sure. It's Kamini Mudli from the NTCSA. I'm a middle manager in program development within Energy Market Services. Thank you.
Thank you. Please remember to forward your presentation to public hearings at nesa.org.za. You may proceed with your presentation and you have 15 minutes.
Thank you, Chair. Please confirm if you can see my screen.
I can see it. Thank you.
Perfect. Thank you. Just want to minimize that. Good day, Chairperson, NERSA colleagues, member of the electricity industry and public. Thank you for the opportunity to present our views and commend NERSA on the development of this critical framework. As NTCSA, we have provided a comprehensive response to the framework and questions. And today I will be presenting a high-level position of what has been also approved at our board level. Okay. In terms of an overview, NTCSA supports the transition and the proposed framework premised on the understanding that it preserves dispatch integrity and financial neutrality of the Central Purchasing Agency, the CPA. The NERSA framework should address the settlement rules, cost recovery routes, and implementation safeguards to preserve the financial integrity of the NTCSA. I think something that has been echoed by previous presenters is that stakeholders are part of technical workshops in order to model the various scenarios to obtain a full appreciation of the impacts and possible mitigations. In terms of the first risk that we want to speak to is that the CPA must be financially neutral and risk ring-fenced. One of the key risks that we've identified is that the vesting settlements can create a net CPA cash outflow when the market outcomes diverge from the strike price benchmark. And without an approved recovery route and a liquidity buffer, NTCSA may carry unfunded exposure. In terms of this, we request NERSA to consider a ring-fenced cost recovery route for CPA net settlement positions, either through the legacy charge or a prudential or liquidity facility size for stressed low-price scenarios. We request NERSA to consider weekly net settlement consolidation of the hedge payments and a defined settlement waterfall credit cover and unsecured bad debt limits. We also request to see CPA settlement exposure statement alongside the generator revenue outcomes. Basically, the position is that CPA should be a settlement counterparty and not the residual risk bearer. In terms of the pricing, also touched on by previous presenters, in terms of the double counting and the separate revenue streams, we request the capacity and ancillary services should be remunerated separately, not embedded in the energy strike price. And the strike price should not, it's the settlement only, and should not influence your short-run marginal cost offers, dispatch, or market price formation. We request that the NERSA example should show the generator outcome and mirror image the CPA cash position, basically a holistic picture. I think similar to what was modeled by, I think it was Meridian earlier on, in terms of the flow of how the cash will go and the energy will go and the CPA cash position. So we support, as NTCSA, transparent benchmark pricing and propose that the final framework should not include capacity and ancillary services in the energy cost. On the vesting volumes, we have a proposal in that the basis for vesting agreements should be on forecasted energy volumes rather than your dispatched volumes. We're proposing that determination of these forecast volumes should follow an annual production planning process, which is kind of overseen by NERSA. And then only after those production plan and volumes have been confirmed should your vesting contracts be concluded. We are also proposing that any reduction of vesting volumes would be best phased in once NERSA has reviewed generation share of dispatched production alongside market dominance factors. And we request NERSA to also consider the Competition Act's provisions in terms of market dominance before just automatically reducing your vesting volumes. In terms of risks and impacts on NTCSA or CPA with suggested mitigations, we have the financial neutrality risk, which NTCSA may be exposed to vesting settlement deficits and unrecovered costs. And so in that respect, we request NERSA to consider a recovery mechanism to maintain CPA financial neutrality through a dedicated clearing account, a legacy charge adjustment, or some kind of RCA backstop. In terms of the contractual risk, the impact is that if there's poorly defined settlement, pricing, and risk allocation provisions, that could leave NTCSA carrying the basis risk and unfunded obligations. The mitigations to that is to include explicit protections in the vesting capacity and ancillary services contracts, including settlement netting, true-up mechanisms, system operator verified metering payment continuity provisions, and clear allocation of your basis risk. On the cash flow and liquidity risk, I think that has also been touched on previously, but basically your sustained low price market conditions could create significant CPA funding requirements and liquidity pressure. So on that, as I've mentioned before, to maintain a dedicated liquidity buffer through committed facilities or ring-fenced RCA over recoveries, supported by frequent settlement netting. In terms of the framework scope risk, we noted that there is not enough detail given, and so uncertainty regarding participation of IPPs, your new ESCOM generation projects, and also distributor-owned storage. So that could result in inconsistent implementation and possible regulatory disputes. So we require NERSA to clearly define vesting counterparties and confirm treatment of IPPs, storage assets, and new generation projects before implementation. In conclusion, Chair, the NTCSA is broadly supportive of the transitional generation pricing and vesting framework, but we require further refinement of the details to enable a successful implementation. The final framework should be clear, practical, and capable of supporting both the market reform and NTCSA's financial sustainability, and avoid leaving NTCSA with unfunded exposure arising from credit, liquidity, or volume risk. We remain committed to working constructively with NERSA and stakeholders to ensure that the framework supports market reform, financial sustainability, and the long-term interests of the industry. Thank you, Chair.
Thank you, Madam Woodley. I will now call upon the members if they've got any questions. Over to you, members. I will start with Madam Maseti.
Thank you, Chairperson, and thanks to Ms. Moodley. Just a few questions of clarity for me. I know that you've touched on some of these issues, but I think there are things that just did not come out clearly for me at least. I just would like to start off with the question on double recovery. I just want to find out how will NTCSA demonstrate that vesting as well as the generation capacity charges legacy charges, Section 34, recovery and Kamani, Ms. Moodley, I think you're not muted. So if I were to repeat the question, and I say that this question has to do with double recovery. So I just want to establish how we can prevent that. So the question is, how will NTCSA demonstrate that vesting as well as GCC and legacy charges, as well as your Section 34 and the system marginal pricing do not recover the same underlying cost twice? How would you assist in that regard? If you can advise NERSA on that. Then the second question is seeking to deal with the potential distorted SAWEM price signals. And I would ask the question as to how will vesting interact with scarcity pricing. You'll recall that we touched on the issue of scarcity being the efficient scarcity, because we have to ensure economic efficiency. So when I refer to scarcity here, is efficient scarcity pricing. How will it ensure that efficient scarcity pricing, as well as balancing and ancillary services without suppressing efficient operational incentives? And if I believe, for me, this question is important for purposes of ensuring that the pricing signals at SAWEM will not be distorted. Then the other issue is around these figures that were mentioned, your 80%, 60%, 70%. So what objective indicators that will automatically reduce the vesting, say from 80%, and therefore what prevents the high vesting itself suppressing the liquidity that is required to satisfy the indicators? I think we believe we need those objective indicators. Earlier on, I mentioned the criteria, but the indicators will assist in this regard. Then perhaps the last question, I'll leave out that question on the CPA, because you have already touched on the issues of credit risk and how the issue of solvency and the fact that there will be capacity issues. You've already dealt with those kind of issues that CPA will be facing. So the last question then that I would ask is about the cost of service evidence that demonstrates favorable treatment of high load factor industrial customers. Basically the basis and the justification for it, where the high load industrial customers will be sort of favorably charged. So if they are favorably charged, what will be that lower sort of a system cost that justifies that like savings or that are arising from them benefiting from a lower sort of charge? And therefore, how should flexibility and contribution during scarcity then be recognized alongside a load factor? I think this is important, just a reflection around high load factor customers that are likely to benefit from lower system cost. So if you can indicate how this is going to be, in terms of evidence, be demonstrated, so that there is not issues of undue favoritism, and also then the contribution, how you deal with issues of flexibility and contribution to scarcity. alongside the load factor. Those are the questions from my side, Chairperson, that I would like to pose to NTCSA so that we can assess what will happen in the market and its approach or actions as it will be the relevant party at SAWIN. Thank you, Chair.
Thank you, Madam Maseti. Maybe from my side as well, just one question. How should NERSA approach or set the flexibility margin allowed on the bidding price over or below other price, which is based on short-run marginal costs to avoid the key risk involved in emerging markets? So over to you, Madam Moodley.
Thank you, Chair. Thank you to Madam Maseti as well for the questions, and I will appreciate the opportunity to respond in writing. Thank you.
Yeah, thank you, Madam Moodley. So on that note, then we are going to go to our next presenter, Madam Herbst. And so, Madam Herbst, can I ask you to switch on your camera and also to raise your right hand and affirm the following? You solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name, organization, and designation.
My name is Penny Herbst. I am not representing an organization. I'm submitting this as a member of the interested public, and I have done so across a number of these public consultations.
Thank you, ma'am. Please remember to forward your presentation to public hearings at nersa.org.za. You may proceed with your presentation. You have 15 minutes. Thank you.
Thank you. And I'm going to try and share my presentation. Just bear with me, because this is the first time I'm using this. And let me just see. Can you see my presentation?
Yes, ma'am. Thank you.
Thank you very much. And let me just go back and start. Okay, there we are. Yeah, as I said in my introduction, introducing myself, this is not the first time I'm presenting, and one or two of my slides might refer to some of the older submissions I've made. I think my first comment, and I'm not going to go into the level of detail that a lot of the participants so far have gone into in the technical side. It would be repetitive, and I don't think that would be useful, but I just want to kind of establish some kind of public consultation framework and context. So as we know, initially, the Electricity Regulation Amendment Bill was released for public comment on the 10th of February 2022, which then subsequently now we're working on and came into effect on the 1st of January 25. At the same time, the electricity pricing policy was also submitted for public comment on the 10th of February. Same date. And these two documents are inextricably linked, and the work that flows from the Amendment Act and the electricity pricing policy has significant bearing on how we treat what is being discussed here and in all the other workshops. And when this 10th of February document was released, between then and now, nothing happened. Now we have a new EPP that's going to be released for public comment on this Friday, the 21st. This framework, this document, the 61-page document, that we've been requested to comment on, and I'm not quite sure who's been requested to comment on, and you will see my raising of that maybe a bit later on in the slides, mentions pricing 140 times. Which is significant, and I'm just wondering, what the implications are of this public participation process when we don't have an electricity pricing policy before us. So I'm questioning it, and I just want to understand, how relevant some of the comments are, especially from a significant part of the electricity consumers are concerned. So whilst I acknowledge that there is the market design and these rules and codes, etc., are a fundamental part of the intent of the ERA, we don't have insight into this pricing policy yet. So although I think there's valuable work that's being done, I'm questioning the timing of this consultation process and how we take this forward. I just want to put it on what I'm saying here, also just want to be able to put this all on record. If we go to my next slide, what I do know is that this consultation journey that we've kind of gone on since I first started giving some input in October 2024 has been an extremely complex process to follow, even for those of us that do have some understanding of the energy sector. And I must admit, even though I've worked in the energy sector, for more than 30 odd years, I am grappling with some of this information and how it all fits together. And I'd just like to highlight in section 1 of the consultation document, NERSA refers to a statutory foundation of its mandate. But in that statutory foundation, you don't touch on section 2B of the ERA or on section 15.1 D and E of the ERA. And I've raised these two sections actually since the beginning of my interventions in these public consultations. I'm just wondering why they're not there. So in regard to the impact on the consumer of all of this transition and the SAWEM and NERSA's role going forward, section 2B relates to economic and social regulation that may arise from, and this may arise from the potential negative consequences of SAWEM. I think that there has been acknowledgement from some of the participants that SAWEM is not a panacea, and there's a whole lot that's happening outside of SAWEM that could also impact consumers. And I think the other part of this, and I'll bring up section 2 and section 15 so we can have just a bit of context of those two sections of the Act. I've got a concern in terms of what I know and don't know, and it still requires thought. Who's actually advising on the pricing modeling of SAWEM and implications of all the other issues that surround the electricity system going forward? Another issue I'd like to raise, and again, I've got a context of the slide going just a bit further on. The fiscus / National Treasury is conspicuous in its absence from these consultations, and it's a concern. They were, and I'm not sure, I haven't seen them on the observers list, but maybe I've missed it, but I haven't seen them in any of these, a number of these, and they don't comment. However, they did comment during some of the SAWEM consultations, and I'll bring back that into this conversation again. And the further issue on the consultation process that requires support, I noted in the last consultation last week, but I've heard it again throughout this consultation process today, that certain entities are proposing technical workshops. I just want to highlight that these technical workshops should not be limited to those proposing them, but all stakeholders should have the ability to be included in this. I actually think one of the regulatory members mentioned that it would be limited. I really have a concern from a transparency and access to information point of view. So I think that needs significant thought. So what does section 15 of the ERA say? And specifically section D and E. We must avoid undue discrimination between customer categories. Yet there may be cross subsidies may be permitted to certain customers. And that whole framework and how it's going to evidence itself in the EPP is critical to understand what the impact is going to be on pricing. Again, I'm saying pricing of this one and all of the other submissions or the other consultations also have a significant bearing on pricing. So I'm really concerned that we don't have a handle on pricing and that we don't have someone independent with no conflicts of interest that is actually really looking at what the pricing implications are. Section 2B of the Amendment Act, which you're not referencing in your document, mentions that the NERSA has to ensure that the interests and needs of present and future electricity customers and end users are safeguarded and met, having regard to governance, efficiency, effectiveness, and long-term sustainability of this ESI within the broader context of economic regulation in the Republic. I'm not quite sure how NERSA views economic regulation, but I also think there's an element of social regulation that also goes to this. Again, I'm concerned that we're not referencing this in your document, and that NERSA doesn't really kind of communicate what its role is going to be going forward with regard to Section 2B and Section 15 specifically, because there is a certain conflict of interest between some of the elements of Section 15 and Section 2B. Let's go to the next slide. Now, this also goes to what I mentioned with Treasury being conspicuous in their absence. During the Market Code workshops, and this all has reference to SAWIM, there was a reference to missing money, and I've brought this up in my previous consultations. I'm just not sure how this missing money, and I think this has come out in some of the other submissions, how this missing money is going to be addressed, whether it's going to be outside and who's going to pay for it and where it's going to pay for it, who's going to pay for it. And in those consultations, we didn't even touch on support to industry. So, for instance, the smelting industry and some of the comments that have come out of DOEE with regard to expanding the remit of how support to the industry is going to be provided. So there's not much information on that, and this also further concerns me as far as some of the discussions are going, because we seem to be doing this on a fragmented basis, and I think we forget what other things we've actually agreed to or potentially put on the table. Now, on the 1st of July, I sent NERSA an email, and I'm going to read it because I think it's useful to read, where I said I raised my concern on the access to information to the broader public, especially from educating the public on the impact of introducing the market. Aside from these technical public consultations, why is NERSA not provided for education sessions regarding the implication on the market on the broader consumer base? Internationally, and this is, if you go and do your research, then one would see this. Internationally, we are seeing a backlash on the impact of electricity markets on the cost of electricity. And I'm just questioning, is there going to be a similar backlash in South Africa? And what is the regulator's role in ensuring a robust and transparent conversation and consultations on the implications? These technical sessions do not provide for broader stakeholder engagement and understanding, and neither have any of the public consultations I've attended on the market done so thus far. If it is the regulator's role to provide for broad stakeholder engagement, if it's not the regulator's role to provide for broad stakeholder engagement, who should provide this critical role? That was a comment I sent to the regulator on the 1st of July when I think it was the Market Code was being discussed. Interestingly, even those that have significant technical support and understanding, and there have been a number of those presentations over time, including today, and in providing the input, there appears to be a significant, and I'm using significant here, not lightly, and potential divergent views across the various consultations, including this one. This raises concern, especially with regard to pricing, which is one of the key issues in this consultation. I just want to now I'm just trying to see if I'm going forward. Yeah, right, there we are. I've brought this up in my previous consultations as well. Section 195 of the Constitution includes, amongst others, the following principles that are related to public administration, and this is very much a public administration process. And I'd like to touch on maybe the second two bullet points. People and public must be encouraged to participate. And I must emphasize, and I think NERSA is quite serious about it not being a tick box exercise, but the transparency and access to information and understanding information, I'm repeating myself here, is for me, it leaves a lot to be desired. And it's kind of a bit messy in my opinion. And that's why I'm also struggling to kind of understand what we're doing and how we're doing it. So I have a question on public consultations. Does this work? I think a mechanism needs to be designed to provide for education, including independent thought and oversight. For me, to a certain extent, and excuse me for saying this, but I do feel quite strongly about it, currently the narrative is somewhat dominated by a significant number of entities that potentially have conflicts of interest. And I'm not sure whether the public interest is really taken into account there, although there have been references to them. A feedback loop that documents why decisions were taken and is required on this public consultation process, as well as what the impact of those decisions were as implementation is underway. I was going to take this slide out, but I thought let me just leave it in. I've gone through that document, and specifically, I think on page 11, the framework, which includes this offer price, the short run marginal cost plus or minus permitted flexibility margin. And then there's a reference to SMRC, but I think that's probably a typo. It's still SRMC, the short run marginal cost, which is fuel cost plus variable plus emissions plus water. Still grappling with this, still don't understand it perfectly. I'm sure I'll get there in the end. But it would be useful for the regulator to confirm the flexibility marginal protocol if this framework actually goes forward, given the divergence. And also the reference to emissions. One of the things that I also see missing, but I'm not sure again where it fits in, it's probably just my misunderstanding. Where does the cost of curtailment fit in? Because I've not seen it, and I didn't even hear NTSA mentioning the cost of curtailment, so I don't know where that fits in there. I absolutely think a list of the vesting contracts are needed if this kind of structure goes forward. I'm saying if because of the divergence. And also, where do these legacy contracts fit in? Hearing NERSA has also questioned these. I mean, my takeaway from the document overall and just this whole process is that market reform does not eliminate costs or volatility, even though you're attempting to do it with, and this is kind of the motivation, it would seem, for this document that's been presented, is to protect consumers from volatility. Let's make no mistake about it. Markets do not reduce volatility. Actually, if you go and look internationally, they increase volatility. So I'm not quite sure why that focus is there, because I don't think we're going to have a stable pricing path. Interesting to see how that plays out in the EPP and what the minister has been saying. Therefore, I think there's some key policy questions that need to be asked. And they're not in policy, but let's see what the EPP says, because it might introduce some other dynamics. What I did note in the document, this is really just superficial stuff. Commencement date, contestable customers, and normative availability are in that definition part, but there's no further reference to them. So I'm not sure whether they're relevant in this document, and if they are, it'll be interesting to understand where. I just want to highlight, this is a previous slide that I've presented. The current system is being built in a very different milieu to that of the past system. The ERA and the 1998 white paper, which some people love to comment on, was extremely light on detail. And with this context on mind, we're still making it up as we go. And in this context matters because I'm still not sure, and I think we should question this, who bears the risk of this, the messiness of this transition? And I like to kind of think of it in the context of de-risking. We're always de-risking, talking about de-risking and the credit guarantee vehicle that's going to de-risk investors. Where in this framework are consumers being de-risked? I think it's really important that we start bringing that to the fore, because it seems that there's a one-sided conversation on de-risking. We're de-risking the traders, and we're de-risking the generators, and we're de-risking the investors. But I don't see de-risking of the consumers. And I love to use this example, so excuse me for bringing this up again. But I think it's important that I'm going to bring this forward for all my submissions. And this is an August price, which is a cap that has been provided for up to 5,000 kilowatts a month for consumers, where consumers can choose a government-backed fixed electricity price, and government is and taxpayers are footing the bill. One commentary in this regard was the overall structure is a left-wing shock in the world that has spent 20 years liberalizing the power sector. And we've had some input from Norway on this market design. And you can hear from my tone that I'm very skeptical about the market and how it's going to, aside from supposedly taking away some of the fiscal risk, which I don't think it's going to, because I think there are going to be significant consequences. But I think it's really important that we go and look at examples internationally, because it does seem that a lot of people that are commenting on the basis that electricity prices are going down. Nowhere in the world have I seen electricity prices going down. Maybe the references to the wholesale market. But when we look at the retail market, I'd really appreciate someone coming back and using concrete examples of where electricity prices have gone down. It can't. We're developing a new system. So I don't know where the reality is in this conversation. And again, another slide that I really like to include, and maybe just focus again, the reform of electricity markets. And this is 2014, and I don't think it's changed. Existing markets are designed around the characteristics of fossil fuel generation and in essence remain unreformed. The problem is that markets as they exist were not designed to and do not reflect the cost structures and operating characteristics of growing new energy sources. And whilst I really appreciate that NERSA is trying its best to address this, I think there are significant risks, and I'd really like, as a final takeaway comment, to understand how consumers are going to be de-risked from some of the consequences. Thank you very much.
Thank you, Madam Herbst. I will now open it up to the members if they've got any questions for Madam Herbst.
Yeah, they're not normally questions onto my presentation, so I don't expect any.
All right. But nevertheless, thank you very much, Madam Herbst, for your presentation. So at this stage, then, thank you. At this stage, then, I'm going to call upon our next presenter, Mr. Gedricks from Renew Consulting. So, Mr. Gedricks, may I ask you to switch on your camera? And
yes.
Also, thank you. And also to please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name, organization, and designation.
Dominic Gedricks, owner of Renew Consulting.
Thank you. Please remember to forward your presentation to public hearings at nesa.org.za. You may proceed with your presentation. You have 15 minutes. Thank you.
Thank you very much. Let me just pull my presentation up. Can you see my presentation?
Yes, I can see it. Thank you.
Thank you very much. So I entitled my slide Standing Up for the Consumer. So the last while, and I appreciate that Nash has been really busy in reshaping the new structures and the new direction the South African energy market is taking. And there's a flood of new concepts, and there's been little time for the market to adapt to new concepts. The wholesale market, vesting contracts, SAWEM, wheeling, and there's all of a sudden a lot of new terms, well, new to us at least, and a catch-up in understanding of how each of these will affect us, how it works, who's eligible, who can apply for what, and so on. So while that is going on, from a public's perspective and from my perspective as well, it looks like a single battle that's actually taking place, where the monopoly of the utilities, be it Eskom and the municipality, is holding on to what they have or had and still have, while asking for new tariffs and charges to fund the current status quo. And we see a lot of this playing out in the courtrooms and so on, where if any change or if any competition is even mentioned, municipalities or so on will go to court, or the tariffs are in court, or there's and this often also delays change as it ties up changes in court. And that's why I say we cannot delay the right decisions. So while everybody's fighting, by the time we're done fighting, there might be nothing left. So that's why I said the concepts for a lot of us are new, but the problems are not new. This is one of the things that, again, I do a lot of work in heavy industrial users, and one of the things I've done over the last while is to ask them, for example, the price of steel that they sold at, or the price of paper, or so on, and ask them, what is your cost per ton that you sell for look like over the past 5 years, and what is the tariff increases? And over the past 5 years, the electricity price has doubled, but most of the industry couldn't put that tariff increase onto their customers, but rather they absorbed it into their own pockets. So they ended up not increasing their businesses, but just rather handing over more money on utilities, water, electricity rates, while not being able to put that back into the economy in creating additional jobs. Or then the municipal debt, I know I bring this up a lot, but it's one of those things where it is really straining the whole market. And I can see when we talk about legacy charges and vesting contracts and who's left paying for what and what are we going to do, at the end of the day, if things like this aren't brought into the mix and the conversation while we are deciding how a free market will look like, the current status quo might drown us in additional debt that puts a burden on all of us. So I believe that the utility debt spiral is playing out in front of us. So the tariffs rise about well above inflation. Customers now can leave with on-site solar, especially leaves. There are fewer customers left purchasing kilowatt hours from Eskom and the municipalities. Eskom and the municipalities need additional money to cover their own cost. They raise the tariffs, which again puts us back into the spiral. And every year when we go around, the spiral's speed and impact increases. So, I mean, again, from 2022 to 2026, we went from 2.3 gigawatt behind the meter solar to over now 9.1 gigawatts of behind the meter renewables. And that is a significant increase. And I don't foresee that slowing down when it is one of the only mechanisms available to many customers to actually taking control over their own costs. And then again, if 1 in 5 kilowatt hours of the municipality is unmetered or losses, it just adds to this whole spiral speeding up, because if 1 of 5 of the current is unmetered, but there's a growing number of kilowatt hours leaving the market, that will then become 1 in 4, 1 in 3, half, and so on. So, yeah. And then on one of the things that I wanted to say to Eskom is, I often hear in these presentations and see that they cite the poor and say, look, if we don't do something about it in the way that we propose, the poor will be left with paying the bill, facing the consequences. And I do think that we have a responsibility to look after the poor. We need to make sure that we don't just leave them behind and say, well, it's not our problem. But at the same time, Eskom can't cite the poor, but also not do anything to deliberately reach them. It's my understanding that only about 20% of those who qualify for free basic energy at the moment actually receive it. And again, if we're looking at costs and vesting and who pays for what, if this kind of energy that is desperately needed for those who need it is well metered, well documented, understood, there's no reason for anybody to have unmetered electricity. It can really form part of the conversation. So instead of just saying, well, look, it's going to impact and reach the poor, we have a situation where Eskom can put up slides and say, we are providing 10 million households with FBE, and this is the cost that we need to pay. Because I understand from Eskom's point of view, where the problem with an open or a free market is that they are saying we cannot be left with the burden of looking after the poorer communities and those who can't afford energy, while the free market only looks after those that can afford electricity. And we all have the responsibility to ensure that we move forward. But at the same time, I feel that Eskom is using them more like a shield and not really doing something about ensuring that what has been promised to these people actually reach them. And then the strike price, in my understanding, in simple terms, is that there's a fixed price agreed upon upfront for part of the harvest, settled both ways, so nobody wins or loses from the weather. NASA sets a yardstick, but that yardstick should be on what a well-run Eskom generation should cost per kilowatt hour and shouldn't be a tariff. The market is supposed to set the real price. And the difference should be settled both ways. So if there's great improvements, then there's a benefit above the line. So the windfall reaches the consumers. Below the line, it's Eskom is topped up by the consumers funding this. But it cannot become a competition tax that protects the monopoly of Eskom. So where it's another backyard tariff increase or a way to ensure that competition cannot get off the ground and the monopoly is protected. We've been paying for budgets and not for energy. Municipality and Eskom on the MYPDs, price inefficiencies, cross-subsidization, municipal debts. There's often rumors or corruption and things that's being proven, but all of this inefficiencies and additional costs just forms part of the price that we are paying, and that is part of the problem. So for years the tariffs have been built on budgets. Eskom's own actions created scarcity. So load shedding and the scarcity in the market was created by Eskom's actions. And then consumers went and they made their own plan. They put behind the meter renewables and they made plans so that they could have electricity if they could afford it. And now the bill for those decisions and inefficiencies feels like it's being presented to us again. When we had the hearing of the negotiated pricing agreements of Samancor and Glencore, it was presented that China subsidizes their energy market to as low as 40 cents a kilowatt hour for their heavy industrial users. But our South African industry is not only not subsidized, but we ask those that produce, hey guys, while you're busy producing, we also need additional money from you to fund our mistakes. And after this has been done, we look back and we see but the wages have increased year upon year upon year from Eskom. And it's not that I'm against people getting a wage increase or people getting paid for the jobs that they do or want to look past the improvements that Eskom has made. But from a consumer, we've been asked, we are in dire need and we've got a lot of problems and we need to drastically fix it. And then we pay more for electricity, and then we end up seeing in the newspapers that Eskom is getting more money, or the people are getting paid more. And it feels like we are supporting lifestyles and choices without getting a better product. So the monopoly, protecting the monopoly. What I hear in the news is we don't want an open market. We are going to court. We'll fight this, and who's going to be left paying for us? But Eskom priced itself out of the market. It cannot now protect itself or be expected to be protected from competition. The private sector runs generally more efficient. That is the elephant in the room. Inefficiency, unmetered energy, and high generation cost cannot be loaded onto its competitors, customers as an extra charge. That is not a transition, that is a toll. I understand there's losses, but who ends up paying for it is important. And again, to be clear, we need the structures, a transmission company, a distribution company, and a platform generation sector, a system operator. We need this. We have to have the discussions, but what we don't need is to carry our inefficiencies across the bridge with us and just say, look, we can't go to a new way of doing things. So I've added 7 fixes and so on. And in the interest of time, at the end of my presentation, I went into detail on every one of these suggestions that I had. I've already shared the presentation with Nasha, but I do think that there are things that can be done. And I think in workshops, these can be discussed. There's a lot of clever people that was here today. And I think if we all get together, we can get to the right answer. But what we do need is to turn the curve. The electricity price index for the past 20 years have increased with 1,000%. We don't want the next 10 years to be another 1,000% increase. We needed the cost of energy to become manageable and to become lower, and that we can all, without leaving the responsibility or putting the poor in a worse situation, but we need to look at that. So who is the ones paying the bill? I support the transition. I think it should be done quickly. It should be done honestly and done right. The structures are needed and inefficiency is not. So I think Nasha has the opportunity in this time to use the changes in the market to really push South Africa and the whole market forward. So yeah, that's it from my side. I have, like I said, I have put the fixes in full and explained them in as much detail as I can. And I've added some additional data at the end of my slides, and I've already sent that to Nasha, but in the interest of time and not taking up other presenters' time as well, I will just pause there for now. Thank you very much.
Thank you very much, Mr. Jedricks. I will now open it up to the members. If you've got any questions for Mr. Jedricks, over to you, members. Yes, let me start with Mr. Mkhize.
Thanks, Chairperson. Excuse me. And thanks, Jedricks, for the presentation. From my side, just 2 things. You mentioned the issue of the debt spiral. if one looks at the SAWEM, doesn't that argument then fall away? And just only putting the emphasis on having a optimal transition, from the as is to the to be, which then I think the issues of the waste bill and everything, if they are inefficient, there is for them as Eskom or any other generator or player in this sector, then would have to face. And then you talking of the low price of electricity. This is my second one. I just want to get from you, how do you think the role players could be held accountable to that kind of, a claim? Because in some other, sectors, we've seen when there's a deregulation or a market liberalization, that the prices seem to go down and then they rise to the detriment of the consumers. Just want your view around that, because whatever claim that we make should be substantiated and those who are making those claims held accountable in a proper run governance framework. Thank you.
So let me hand over then to Mr. Debrits to answer.
Thank you very much, Mr. Mkiza. I appreciate the questions. I do think that the SAWEM has the ability to definitely turn around or stop the debt spiral. And if it's a transition to an open market, there's absolutely the opportunity for it to be the change. However, as today's presentation is evident, if the market is inundated with additional costs and legacy charges and burdened with double counting and inefficiencies, then no, the death spiral will continue. Or the simplest way, I think the best way for me to put it is that I'm scared that some of this allows customers, or if it's not done correctly and fast enough, then instead of SAWEM reaching customers and being a real, and the energy trading market being a real option or availability for people to reduce their energy costs, it might be stalled so long that they only have two options: either increase their behind the meter renewable energy, or to reduce their consumption. And both of this then expedites the death spiral. But if it's done correctly, then absolutely, then we move into a much better position and a much better market. Yes, and then in the interest of time again, I've taken down the questions and wrote them down nicely, so I'll make sure that I answer them in its entirety in writing and send them to you.
All right. We will now move on to our next presenter. It's Madam Kassiar from Scatec. So, Madam Kassiar, may I ask you to switch on your camera and also to raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name, organization, and designation.
My name is Liesl Kassiar. I'm the Senior Business Development Manager at Lara Energy.
Thank you. Please remember to forward your presentation to public hearings at nesa.org.za. You may proceed with your presentation, and you have 15 minutes. Thank you.
Thank you very much, Chair. Can you just confirm that you can see my slides?
I can see it. Thank you.
Okay. Thank you very much, Chair, and thank you for the opportunity for presenting. I know that we are, in the interest of time, I'm probably going to be repeating a fair amount that's already been said, but we as Lara Energy would just like to make a submission in that we are supportive of the transition, but we would like the reform to happen in a manner in which we don't weaken competition, obscure costs, or create an open-ended system for customer liabilities. If I move on to my next slide, I just wanted to spend 2 minutes on who we are for those who are not aware. So we are what we call an integrated energy trader, and we are made up of a shareholding between Scartec, which is an IPP, Stanlib, and Standard Bank. And so we are a trader that participates in the markets by owning our generation assets and then on selling it through wheeling mechanisms, through an aggregation of commercial and industrial customers. We have made quite a detailed submission in writing to NERSA. So for the purposes of today, I really just wanted to focus on 5 key elements of our submission. And I've framed it in the following 5 points, which I'm going to cover briefly in these 15 minutes. So the first point that we want to cover is the concept that each cost needs to be recovered once. We then want to unpack that generators need to retain controllable risks. We want to highlight the safeguard that both hedge legs need to use identical measures. We will look at why qualified participants need to be treated equally. And then the last point is around the vesting needs to decline to a fixed end date. And I'm now going to just touch on each of these 5 fairly briefly. So when we look at the first one, our main message here is that each cost should only have one approved recovery route. And what this is really talking to is that currently how the framework is drafted is that it obviously contains several payment and charging mechanisms in the form of capacity, ancillary services, energy settlements, vesting settlements, and legacy charges. And we are not saying that these are not reasonable, especially if they are taken in isolation. But the risk arises when there's the opportunity, when the same cost category appears in one or more mechanism. And so then there is potentially the ability for costs to be recovered through more than one way. And this is really where, as Lara, we are asking for clarity on. And we are asking that maybe one way in which this can be addressed is for NERSA to require a consolidated cost recovery map with clearer calculation models before the approval of this framework is implemented. The second point that we want to focus on is, let me just make sure I haven't moved on. So the second point that we wanted to focus on is that capacity payments should reflect today's services. And I know that this has been a point that's already been raised by many speakers, and in particular Meridian Economics. And so this is really about the concept that the current capacity payment should not come or arise from servicing historic financial obligations. So if you look at it, really, a capacity payment should answer the practical question of what is the efficient cost that is avoided if required capacity is not kept available for the delivery year. So a capacity payment should be something that points forward and not a mechanism that looks at historic revenue requirements. Another point that we want to raise here is that it should also reflect performance. So where capacity is unavailable or is not offered as required, then the payment for this service should kind of reflect this non-performance. What we also want to say is we're not arguing that legitimate legacy financing obligations. Sorry, I can hear that someone else is maybe not on mute at the moment. Our point here was that we're not arguing that legitimate legacy financing obligations are not treated, but our main argument here is that they should not be treated through the mechanism of capacity payments. Our next point is around preserving a meaningful market price, because this is kind of critical to the functioning of the markets. And what we really were trying to get across here is that, as we know, in each settlement period, the last generator required to meet demand sets the price received by all scheduled generators. And we know that Eskom generation in itself is of sufficient scale to influence that price on its own. And that is why NERSA proposes to anchor this kind of cost on the short run marginal cost. And we support this approach. I think the issue that we are seeing, which is not clear in the current framework, is that the rule governs the price at which Eskom can offer, but it doesn't really address the fact of what if Eskom chooses not to offer it at all. So in many ways, if a capacity is available but not offered, it's actually a way in which the market can be gamed. And I think previous speakers also spoke to this point. So our kind of request here, or kind of point of clarity that we're seeking, is that both the price needs to be regulated, but also it needs to contain a duty to offer. Because if this is not in place, it does kind of result in a non-meaningful market price, which ultimately has impacts on the end consumer. Our third of the 5 points speaks to the two hedges, the upstream and the downstream hedge. And really the key point here on this slide, and as you'll see the following slide, is actually kind of maintaining the risks that the CPA covers. So what we're kind of arguing here is that both hedge legs should be treated exactly the same way. Both in terms of how they are measured, the interval, and the same volume. So the upstream contract with Eskom generation and the downstream contract with eligible load-serving entities should use the same system marginal price, the same settlement interval, and the same total vested volume. And why we say this is important is that if this doesn't happen, then there's significant risk that the CPA carries. And how it's currently framed is that invariably this risk or this mismatch in funding will ultimately be recovered from customers. And so we're arguing that to prevent this and to prevent unnecessary charges being lumped into the legacy charge, we argue that we need both hedges to be matched. And following on from that, we also feel that this kind of a risk that sits at the CPA level could be better identified in the current framework as it is written. Because as we know, the CPA will be a significant markets counterparty and is exposed at quite a few levels. So it's exposed at a market and basis risk, and that kind of comes from what we've just explained around a mismatch between the two hedges. There's volume and allocation error that it can occur. There's kind of counterparty default risk. There's liquidity timing, and there's potential governance conflicts that all sit at the CPA level. And we're asking that this probably needs to be addressed in a bit more detail before the current framework is approved for implementation. The fourth point that we're wanting to highlight is what we've entitled the protection of the incumbent. And this is really about maybe just examining the downstream hedge. And we know that this is an insurance against the wholesale price. And we support that customers have it during the transition period. But as it is currently drafted, this kind of downstream hedge only goes to the incumbent distributors, and it's allocated for a period of 5 years. So if you look at it as a whole, first it gives the incumbent a cost base that no other independent party or retailer can effectively compete against. Secondly, as and when the contestable market opens, at the same moment, you could argue this downstream hedge gives the incumbent a structural cost advantage inside the market. And thirdly, because the allocation follows share of total demand, the hedge tracks the volume of a supplier rather than holding it accountable on the cost it incurs or the service it provides. So the main message here is we'd just like to make NERSA and stakeholders aware of the potential other knock-on effects that the downstream hedge can actually result in the market when it is introduced. One of our last key points is that for any transition to be effective and measurable, there needs to be a predictable decline of the vesting contracts. And so currently, as the framework sets it out as a 5-year term, but we argue that there's no publishing of a reduction schedule, measurable triggers, or even information on how potential extensions would be dealt with. And so we argue that for kind of market credibility, that these kind of measures are clearly outlined so that everyone that's participating has a clear understanding of how the vesting contracts are going to be declining towards the fixed end date with clear kind of guardrails and measurable triggers so that we don't end up in a situation where we almost have things being treated on a case-by-case basis. My last kind of 2 points are just around, and it's something that other stakeholders have also raised as potential suggestions, and that is that this is a very complex topic, and the risks of getting it wrong are great, and many have actually pointed out the risks to the consumers, and that ultimately we should be approaching this topic from what is best for the consumers. And so as Lara, we also had put forward the concept of potentially setting up some working groups that can kind of unpack these very technical questions, and possibly in these working groups also have more sharing of available data so that there's transparency around the methodologies and the data that is going to be used. And we've seen this working quite well in the trading rules space. And so lastly, we just want to end on the concept of what we call the ecosystem of reform. And this is really around the point that, as we all know, there's currently quite a lot of key legislative and instruments that are being reviewed and assessed as implementable in this future market. And all of them are critical. But we would just like to encourage that they are viewed in their entirety and holistically. Because if each instrument is being consulted on separately, we run the risk of potentially constraining the same commercial space twice. And so we're just wanting to make sure and appealing to NERSA that kind of all of these instruments are assessed as an ecosystem of reform so that we don't end up potentially constraining certain things doubly through the different instruments. And so, Chair, I think that's where I will leave my presentation for now. Thank you.
Thank you, Madam Kasia. I will now open it up to the members if they've got any questions. Over to you, members. I do not see any hands for questions. So we'll now move to our next presenter, Mr. Hernandez from the Regulatory Assistance Project. So, Mr. Hernandez, may I ask you to switch on your camera and also to raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth? Mr.
We don't seem to have him on the call.
All right. So if we don't see him to have Mr. Hernandez on the call, it means that we have now gone through all the presentations that were planned. And so we no longer have anyone left to present. So on that note, then, I am going to take this opportunity to thank all the presenters for all the inputs they have given, and also to thank the members of the regulators for their questions, and also to thank the observers and also the team at NERSA. From here onwards, obviously, NERSA will take into consideration all the points that were raised and come up with the next steps. Or I see there's a hand here. Maybe let me allow this to come in. Paulette Farron.
Thank you very much, Mr. Chairman. I just want to share that Mr. Hernandez was able to join to ask if he would still be able to make his presentation.
Or was he able to join, is he?
Yeah, he was having some technical difficulties. Sorry about that.
All right, no, that's fine. If he has many minutes to join, let's allow him to present. So thank you for that. So, Mr. Hernandez, if you can switch on your camera. And
I have, sir. And I will share my presentation.
And yeah, please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are about to give before this panel is the truth, the whole truth, and nothing but the truth?
I do, sir.
For the record, please state your name, organization, and designation.
My name is Cesar Alejandro Hernandez. I am the head of the Energy Systems Innovation Team at the Regulatory Assistance Project.
Thank you. Please remember to forward your presentation to public hearings at nesa.org.za. You may proceed with your presentation and you have 15 minutes. Thank you, sir.
Thanks a lot, sir. Let me share my screen. Can you see my screen?
Not yet.
Just a second then.
I can see it now. Thank you.
Thanks a lot. Thanks a lot. My name is Alejandro Hernandez. On the behalf of the Regulatory Assistance Project, I'm very happy to share our comments in this public consultation, and we are honored to be able to contribute. Just as a background, 10 years ago, more than 10 years ago, I was a public servant in the Mexican government, and I was in charge of designing the vesting contracts for the transition to the wholesale markets in Mexico. This was, for me, was a project that took 2.5 years of my life. I learned plenty of things, and our only objective is to share our thoughts, mine of my team, on things that have been done not only in Mexico but also in other places, and how they can improve what has been proposed by NERSA. First of all, we would like to comment on the overall structure. We believe that the most important things that needs to be considered are already there in the proposal. There are many things that the framework gets right. First of all, vesting contracts, they take the shape of a financial vesting hedge. This has very interesting properties. First of all, it keeps merit order dispatch, it drives efficiency, and allows efficient price formation. This is an excellent point. The most important part is that this provides as risk-sharing mechanisms for consumers. One of the things that we are worried about when we open a wholesale market is the fact that prices may hike later. Prices may hike if the fundamentals of the markets change. If fuel prices increase, it's natural for electricity prices to increase. But it won't do it disproportionately. No, it would be reflecting not market power, for instance. What it will be reflecting is real scarcity, and this provides the right instruments. The second thing that it's very important is that vesting contracts are confined to existing generation, and this a well understood mechanism. It's not a mechanism to drive new investments, it's to provide a transition mechanism to the new market framework. There is also an important point that the framework already recognizes different costs, those who can be driven by either fixed costs, by ancillary services, by energy costs, and there are different recovery routes. And this is the right principles, and it has been considered. And finally, there is a vesting reduction that is being considered, and it's in principle, this is right. This should be linked to the way as competition increases further, we can start thinking on moving away of phasing down the vesting contracts. We believe all these are very good elements. Our recommendations go in the direction of refining, making these considerations stronger, making it more effective. One important cost, and I will go later into the details in my presentation, we have to recover each cost only once. Right now in the current design, there is the risk that capacity, for instance, can be recovered in two different channels, and it could be recovered twice, moreover. So this is an important risk that needs to be addressed. An important one is the fact that we have there is a capacity payment, but there is not enough detail on how this payment could be done. And this is an important risk. Our recommendation is to pay for capacity when capacity is needed. And this is during the times of stress. I will go this way. It's not to be paying all year long small payments. It's to do big payments in a few number of hours when the capacity has actually value. A third stream of recommendation goes on simplifying and limiting the CPA exposure. We believe that there is some important exposure for the CPA. And the fourth is to make sure that we complete the market power mitigation tools that are needed. Now, the vesting contracts, they provide a very good tool to prevent market power, but they contain market power. They don't disappear market power. As long as there is no real competition in the market, without this kind of contract, the natural thing would be to have higher prices than the competitive benchmarks. So let me go into the details of these recommendations. On the first recommendation I have put forward, as we say, there are two different ways in which capacity could be recovered. One would be, as it is in the current proposal, to have a strike price that somehow already considers a higher price above the variable cost. And those rents, they are basically meant to be that they are adjusted in such a way for them to pay for the fixed cost of the plants. This includes capacity and ancillary services and energy. The other route will be to fix a strike price basically equal to the variable costs of the plants, and to pay separately per megawatt payment on capacity. So we could go for one way or the other, but right now, as the proposal stands, as the way as we understood it, we have both routes. So we have to pick either one or the other. There are examples in the case of Singapore. Singapore recovers the capacity inside of an energy-only market strike, the same as NERSA proposes. Countries like Mexico, countries like Ireland, they have kept separately. We have a low strike price that reflects variable costs, and we have a fixed payment for the capacity if the capacity shows in the right moment. And there is already some among the examples, the example that is already included in the proposal. This risk has been already it can be noted already. As of if we are paying a capacity payment, there is some thought that needs to be given in order how to pay for this component. Very often what we tend to do is we tend to replicate what the PPAs do, but this is not a PPA. It's not a traditional PPA in any case. It's not the kind of PPA that we have when we have a vertical integrated utility. No, now we have a market, and the market gives you a lot of information. Part of that information is to give you when is the most valuable hours for the system, where all does this 50, 100, 200 hours where the system is really stressed. And we have to take that information into account. So what we suggest is to make a payment for availability during those critical hours. Those hours, in some places, they do it well in advance. In Argentina, in the beginning of the year, the system operator says, This is a summer peak demand system. In the afternoon, in the evening, these are the peak hours during working days, 2 hours per day during 3 months, for instance. In other systems, they do it almost in real time. The French system operator has a similar mechanism, and it calls 1 day in advance, saying tomorrow is a critical day, and generators who will be available are going to be credited with a capacity payment. And it's also in the case of the Mexican system, it is exposed. At the end of the year, the system operator publishes which were the critical hours, and if generators were available or generating, they are credited a capacity payment. I recommend to take these kind of characteristics into consideration into the capacity payment. I would also consider this to be the payment of the capacity. It should include the fact that many of these plants, they have been already depreciated. And there is no point of paying for a new plant for something that has been already depreciated. On the contrary, there are very brand new plants that are just getting to operation. It's important to recover the full cost and to acknowledge that there is debt behind and that they need to be fully paid. But there is one plant that has fully depreciated, but we want to keep it alive. That's perfectly fine, but we don't have to overpay that. Finally, how to give this capacity payment is a standard practice in markets like PJM. Those generators that receive a capacity payment, they have a must offer obligation. This is what you get on exchange for these payments. You have to bid, you have to make a competitive bid. That's what you are getting thanks to your payments. Of course, we have our preferred choice. Our preferred choice is to have a strike price that is linked to the variable cost and to separate the capacity payment. This is one route. If NERSA decides to keep the capacity value on the strike, this is a possibility. This is the Singaporean approach. That's another possibility that we don't suggest, but it's a legitimate. In that case, it will be important the capacity payment to be net out of the rent that is taken in the energy market. On the next recommendation, we believe that there are many sources of imbalance for the CPA very quickly. The way it has been designed, where we have the upstream and the downstream contracts that are not symmetric, it creates a potential mismatch on the strike price basis. This is the first one. There's also another risk on the volumes. There could be the upstream settles on a notional value, downstream is lower of the actual contracted volume. So there is also another mismatch. And finally, there is also a cash flow timing asymmetry. Cycles might be different, and so the amount of money that is arriving might be different to the one that is already paid. So there are a few sources that can or not interact among themselves. Certainly, reducing this to a single contract, which is basically a pass-through from the CPA to the downstream, that will resolve the issues. We could keep a single call option contract for the generator, and whatever rents are coming from that can be given, rents or costs, by the way, they can be given just pass through to the distribution companies. Another thing that we would like to recommend is to make a very clear decision. Right now, this has been shown as a one-way option contract for difference. We would suggest to have a very clear definition for what is called in other systems a call option. It looks pretty similar, but it's not. Basically, in a call option, whenever the market price is above the strike price, the generator needs to be paying back all the rent. The generator is meant to be available, no, and it's supposed to be creating some sort of rent. In that case, it gives these rents all to the consumer. So we would like to ask for a clarification if a contract for difference of one way, no, is what is exactly proposed, and to provide this kind of a structure in which the generator is always, as soon as the prices are above the variable cost, they should be giving back those rents, either they generate or not. Why do we insist so much on that? The large share that ESCOM will have in the beginning of the market, we all basically created all the conditions for market power. This will create an efficient pricing formation, and at the same time, both the generators and the consumers will be protected, no, from the wholesale pricing. So this is something which is very important property during the beginning of the market. We would like to propose to define and to fix the strike price and define the margin, as we have already said. On the strike price, what we are recommending is to have a plant-specific energy-only short-run marginal cost strike price. I will be repetitive on what we have mentioned. This is one of the characteristics from this is that this can anchor ex-ante offer mitigation. No, for the market monitor and for the regulator, it will make life easier to understand what is happening in the markets and if there are competitive bids. This needs to be generator specific. No, having a fleet average strike distorts the merit order and misstates the inframarginal rent. So we know the parameters of these plans. Let's use the information of these plans in order to have a tailored strike price, which again is financial, right? So this is only what the plans are meant to be able to doing. The generators' decisions may differ because they might differ on maintenance times, or they might differ on other issues to turn off certain plans and so on. But at least we have a good representation of what the fleet can do, and this is what is the basis of the contract. Regarding how this could reflect in the market, what we would suggest is to have bid offers, which are basically a reflection of the short run marginal cost plus a certain margin. It doesn't mean that the generators won't be able or will be obliged to provide always their variable cost as the bid. There is a margin because there are many things that change the cost of the plants. Temperature, for instance, can reduce the capacities of the plants. So it is important to provide, in some markets, it's about 10% of flexibility margin. And this can be how the bids are offered. And certainly the vesting contract and the mitigation in the market, they can make it stronger to each other. It will make life of the market monitors way easier. Finally, I would like to emphasize this point. The vesting contracts, the hedge buys times, no? We can simulate a competitive market thanks to the vesting contract, no? But on the long run, the competition will only come as new entry happens. So there are many tools that can be used, but there is nothing as having more competitors in the space, in the market. One of these tools that needs to be completed is the ex-ante offer mitigation. Many markets, before creating prices, they screen the bids, they check if they are not too far from the variable cost, and they used corrected bids if needed to come up with prices. Having an independent market monitor, independent from the participants, is something that we also recommend, is having basically a dedicated consultant that can team up with the regulator in order to understand what is happening on this very data-heavy industry. Having a binding metric key tapper, basically triggering the reductions in the vesting contract as competition arrives. Competition will arrive at different moments in different segments. It might not be the same. For instance, during daytime, we might have competition faster because more renewable solar generation might bring this much faster, right? So in certain moments of the day, in certain moments of the year, even could happen much faster than in others. As we have developed this metric that allows to understand when competition is already there, we can start reducing the contracts. And finally, it would be very important to provide visibility and a credibly entry pipeline because this is only half of the picture on the existing generation. The other half is how the new one will become. This is really the completely complement to understand if this is a complete instrument, is to have a clear vision on how the new entry mechanism for the new entry will happen. And I will stop sharing now. I'm happy to receive your questions.
Thank you, Mr. Hernandez. We'll now open it up to the members for questions. Over to you, members. Maybe let me start with one question, Mr. Hernandez. Just to find out whether are there vesting contracts in Mexico. Sorry, are the vesting contracts in Mexico public? And are you able to share some of these? Also, did you finalize the Mexican framework for these vesting contracts? And are you able to share a copy? Over to you, Mr. Hernandez.
Yes, the methodology that was used to develop the vesting contracts is public. There is a PDF that is available and that I'm very happy to share along with my presentation. As when the final decision of vesting contract arrived, there was this publication of the methodology that I'm very happy to share.
Yeah, thank you for that. Maybe in terms of sharing that document, if you can send it to us, yes, at public hearings at nersa.org.za.
Will do, sir.
No, thank you, Mr. Hernandez. I do not see any other hands from the members. So on that note, then, let me thank you for your presentation. And then at this stage, thank you, Mr. Hernandez. So at this stage, then, we have come to the end of all the presentations that were planned for the day. So I would like to take the opportunity to thank all the presenters, also to thank the members of the regulator for their involvement in terms of soliciting questions. Also, all the observers in the various streaming platforms, and also the team at NERSA as well. So at this note, then, this public hearing is adjourned. Thank you very much.
Thank you, Chair, everyone. Cheers.